Your Lordship, and Honorable Family Court in this, Your Lordship, has provided interim visitation rights, Your Lordship, along with the video calling for every alternative date. The child is suffering from intermittent squinting of an eye. Kindly have it for tomorrow. Every alternate days they ordered for.
No. That when is order passed?
Order has passed for visitation rights for
When?
twice every month, Your Lord.
He said when is the order?
On 1st, Your Lord. On 1st of August.
Yes.
Uh,
Take it. Yes.
kindly have it for tomorrow.
Yes.
Your Lordship, there is another matter. It was posted on 29th, Your Lord. Date given matter. It was not moved before the court.
Look at it. Why? Yes.
Tomorrow, Your Lord.
We'll see. Yes.
Lordship, the petitioner's case for Your Lordship, the petitioner's case for divorce in the family court was dismissed by the family court. Your Lordship, we have to challenge the said matter.
How can you challenge that matter before this court if divorce is granted?
Lordship, the matter is.
If the divorce is granted, you can't come.
So divorce is not granted, Lordship. The husband is the one who filed the matter.
Huh?
The husband is the one who filed for divorce in the family court. The matter was dismissed, taking that on merits grounds.
So even in that case also, how can you file a writ petition before this court? You have to file an appeal against that. Is it a pending matter?
No, Your Lord.
You cannot file. It's a final order. It has to go before the division bench, not before this court. Yes, next.
Your Lordship, there's one more matter in this matter. In
One advocate, only one memo. What is it?
Your Lordship, this matter in OS 125 of 2018, temporary injunction was granted against.
What is the MFA now? Which year is the MFA?
It's a fresh matter. Lord.
Fresh matter, if office objections are complied with, it will come tomorrow. Yes.
I'm for the respondent. CPC of the year 2022. I am for the respondent. My suit for partition before the trial court was decreed. Some of the defendants were placed ex parte. They had filed a miscellaneous petition that came to be dismissed. That is challenged before this court. I filed an application for early hearing, and now our FDP proceedings are also concluded. And the final DP is drawn, and thereafter I have to take possession. I have filed.
What's this matter next Tuesday?
My lords, this is RPFC matter, my lords. This is disposed on November 2023. Now trial court has issued the NBW against the petitioner, my lords. This matter was dismissed for non-prosecution, stating that the petitioner has not filed acknowledgement having deposited the amount before the trial court. I have deposited, and
What
that
are you doing from November till now?
that is there are compromises going on, my lords. Then they have taken
No
the
urgency for that.
my lords, please, my lords. NBW has issued, my lords. Fourth is the matter is they are taking it.
If you don't pursue the matter and if you don't obey the orders of the court,
No, my lords, I have
November-
filed the
November it is dismissed for whatever
On-
reason. No, we are in September. Almost a year now.
last
Come and
date of
say that
hearing, my lords, that a trial court has directed,
whenever you feel that, then there can't be urgency, you file it, let it come, we'll see.
my lords,
Yes.
urgency is there, my lords. NBW has
Will
issued.
not
against it.
consider these kind of cases where the litigant is not vigilant and you just keep quiet. Whenever you feel like, whenever you remember, you come to the court, not that way. Yes. Yes.
This RPFC matters, the respondent has not deposited. By this. We've taken
Which year?
2021.
Take it. Post this matter somewhere next week, Thursday or so. Yes.
My lord, fresh matter, my lord.
Fresh matter, any fresh matter, office
Mm.
objections are complied with,
Section
it
was
will come.
complied.
It will come. That standard instructions. Take that memo, find out from the registry. Yes. Yes.
Page adjournment, list 1, page 1, serial number 1 to 3. Page
Well-
2, 4 to 8. Page 3, serial number 9 to 13.
Your Honor, serial number 11, Your Honor. I've informed that the RPF of the appellant.
At the request of both the councils, post this matter on 21st of October.
My lord, serial number 3.1 and 3.2, my lord. I appear for, I'm the proxy counsel appearing for the respondent, my lord. The respondent counsel is suffering from dengue, my lord, and the same has been informed to the appellant's counsel, Mr. Chandranath Dariga. Therefore, my lord, I'm seeking an adjournment, my lord. A week's time may be granted.
What is this 2016 matter? That's why it is listed on the top of the list.
Uh,
And the 3.1 council for the other side is here.
it is due to the health reasons, my lord, the present adjournment is sought.
How many years you want this matter to be post this matter on Monday, on Tuesday? Yes.
Tuesday, please,
No
my lord.
further adjournments. Who, you're appearing for which
My lord, I'm
respondent?
proxy counsel appearing for the advocate on record, Mr. Varun Gowda.
Sir?
Varun Gowda, my lord, 3.1 and 3.2.
3.1 at the request of land counsel the respondent. Post this matter on Tuesday. No
Tuesday.
further adjournments will be granted. Yes.
Please, great.
Page number 4, numbers 14 to 17, page 5.
Serial number 17, my lordship. I am appearing for appellant's lordship. 1 week accommodation. Senior is not well, my lordship.
They appear for
Appellant's lordship already intimated to the respondent's counsel, my lordship.
counsel on record is unwell. And the same is informed to the counsel for the respondent. Post this matter on 17th of September. Yes.
Much obliged.
Yes.
5, serial number 18 to 23, page 6, 4 to 31.
Serial number. Or serial number 30, a week time may be granted, an interim order may be extended, my lord.
31.
30,
You appear for whom?
appear for the petitioner, serial number 30. 30.
What about respondent? Respondent is served. At the request of land counsel for the petitioner poses matter on 30th of September.
Interim order may be extended, my lord.
Term order earlier granted is extended till then. Yes.
Serial number 29, my lord.
Yes.
Serial number 29, my lord. 1 week's accommodation, my lord. Today I'm not well. Severe throat infection.
Inform the other side.
Yes, my lord. I've sent a message also on the morning.
Inform the other side. On 30th of.
Serial number 28, my lord, in this case.
20.
28, I represent the respondent in this case. Petitioner counsel has informed me in the morning, sir, he is not feeling well. Moreover, I have, even myself, I have to file the objections.
Same. 28 also same.
Serial number
Much obliged.
25 and 25.1, your lordship. Serial number 25 and 25.1. I'm appearing for petitioner, seeking short accommodation. I've informed the other side.
Post these matters. At the request of land counsel for the petitioner. Post these matters on November 19th.
Interim order may be extended.
Why should it be extended?
Senior is not keeping well. Next week,
All matters you are, you want, all of you want adjournments. Why should these matters be listed? Somebody who are interested, who are moving the slip, their matter should be taken.
short accommodation in lordship.
We'll give a long accommodation without extending the interim order.
Yes, your lordship.
Pose this matter on 18th of September. Till then, the interim order earlier granted is extended. till then.
ಮಾಡ್ಕೊಂಡ್ಬಂದ್ರಿ
ಇವಾಗಲೇ ಕಡ್ಡಿ ಹಚ್ಚಿದ್ದೀರಾ ನೋಡಿದೆ ನಾನು.
ಇಲ್ಲ ಅವಾಗಲೇ ಹಚ್ಚಿದ್ದೀನಿ.
Yes.
Page number 7, serial number 32 to 34, page 8, 9 to 48, page 9, 9 to 41, page 10, 42 to 45, 44.
Yes. On the list.
Page number 1, for being spoken to first.
My lord, this honorable court was modified the family court order. I am for the respondent. Modified the order of the family court order, even on this honorable court, and exercise the visitation rights of the father, my lord, twice the month, first Saturday and third Saturday of the every month. But unfortunately, first Saturday of the next month, your honor, it was holiday this month due to Ganesha festival, and October 5th of the month is the Honorable High Court has been declared Dasara holiday. My visitation rights is can't. My visitation rights is unable to.
Lords may kindly appreciate.
Is
They
the
moved
reason,
an application before the trial court, Lord.
We have
It
already.
is the 7th
one thing, you moved her for being spoken to.
Yes, my lord.
What is wrong with the order?
The order is not
Okay.
wrong, my lord, because the
We
order
have to
was
seek
passed
for
on
review of the order, my lord.
Because you're
First-
seeking
first
review of
order-
the order.
first Saturday is holiday, my lord. That is the reason.
Review of the order because your
Unable to
lordships
we
are
have-
already released the copy
But
and it is.
every matter, now once order has to be passed, now again for being spoken to, then thereafter execution will be done by the High Court. What is
But
it?
we approached the trial court, Your Honor, where the trial court straight away rejected my application.
Lords may kindly appreciate.
Saying that you.
Trial
go
court has
on
not rejected, it's a false submission.
Father can exercise the visitation rights on first and third Saturday from 1 PM to 5 PM at mediation center of the family court. No, if not at the family court, wherever, no, what will happen
Lords
is,
may kindly appreciate. Once
understand.
again, Milan, I will let
please
me.
understand,
please.
not only, not about this week or whatever it is. Now, you wanted it to be in the mediation center. So whenever, on some days when the mediation center or if there are general holidays, there should be something
Milan, kindly appreciate. They moved an application before the trial court. Milords may kindly.
before going into
No,
those
1 minute,
technicalities.
1 minute, I'll read out the order, Milord. However, as the first Saturday, September 2020 has been declared holiday, in order to comply the orders passed by the Honorable High Court, it is just and necessary to direct the mediation center to make arrangement to the petitioner and the respondent for exercising the visitation right at mediation center as per the orders of the Honorable High Court. Hence, office is directed to issue an intimation to the member secretary DLSCA along with a copy of the order dated 7/8/2024 in WP number so and so to make arrangement to exercise the visitation rights. This is the order of the trial court.
But
I
the
don't know what
trial court-
fault my friend is finding with
And this
and
one-
unnecessarily troubling your lordships.
My lord, we went this order with the mediation center, my lord. The mediation center director is saying that you already general.
And
already
this
has been
court
declared
will
by
do all those.
Honorable High Court and State Government of Karnataka.
No,
So that is the reason.
what this court has to monitor, this court should monitor the trial court
But
order.
unfortunately, we
Or
are
what the trial court is doing, or now what the legal services authority secretary is saying.
So. but
Lords may
already-
kindly
Don't,
because
understand the
already-
situation.
kind of application.
My lord,
This
any
court has
any
passed
other
an
day,
order.
my lord, any other day, other
This
than
court
the
has passed an
compassionate, the
order.
same order, my lord.
Now you have to question that order. In this order, there won't be any
Please,
modification.
Milord.
Modification, not now, I requested, by,
This
my
court by
request,
order
Your Honor,
dated
some
7th
other day.
August 2024 has passed an order permitting the father to exercise the visitation rights on first and third Saturday from 1 PM to 5 PM at mediation center of the family court. After the order is passed, the the respondent has approached the trial court stating that a Saturday is a holiday, and on that day, the mediation center is not, on that day, he is not able to exercise the visitation. Then by order dated,
Order dated 38/2024, 30th of August.
2024, the trial court had directed the Legal Services Authority to accommodate the petitioner, the respondent, to exercise visitation rights. Now, the grievance of the counsel for the respondent is that the said order passed by the trial court is not, the Legal Services Authority is not obeying the said order. All those things are not a part of this order. And on that, first of all, moving an application for being spoken to is a pure abuse of process. Yes, dismissed. Yes. Oh, yes.
Number 2, Tier number 1, Prabhu Tungigi, an appellant.
The appellant is not of the age about 84 years. Not of the suit is for not of the mandatory injunction to quit and deliver the vacant position of the not Schedule B property. Not against the not of the respondent number 1 and 2, who are the not of the husband and wife, or wife and husband. Not of the suit schedule property is the not of the self-acquired property of not of the plaintiff. Not of who inherited the property from her mother. Not may
Now,
take
what is the relationship between the plaintiff and the defendant?
relationship is not of the plaintiff is the not of the mother of respondent number 2.
Plaintiff is the mother.
Mother of
Defendant
respondent
is?
number. First respondent is the not of the wife of respondent number 2.
Plaintiff is the mother-in-law, my lords.
Plaintiff is the
Mother-in-law
mother-in-law.
of the defendant number 1.
Defendant number 1 is the daughter-in-law.
Daughter-in-law.
Yeah, yes.
Not.
What is the application that you have filed?
Not the application they had filed, not, before I could come, not this petition is not the pending since not 2018. Not OS is filed on 17/11/2018. Not the on 29/5/2024 itself. Not the matter was posted for not the final argument.
What is the date?
29/5/2024.
Hmm.
Matter was not the posted for final arguments, not after not the evidence and not the on not the application was filed on not the wait, application was filed on 3/7/2024. Before not I could say not on not the there was a interim order of not the status quo not that is on. But the interim order of status quo was not the order by the not the trial court not earlier to not the 2019 not. I'll give the
What
date.
is the interim order?
Not interim order maintain not status quo between the parties.
Hmm.
Not such being the fact not on 3/7/2024 not.
Yes.
Not the respondent number 1 filed not the application seeking to not the provide access to the common areas.
Access to the.
Access to the common areas. Plus, we have filed an objection. Suit is for the lot of the 2018. Till 2018 to 24, there was no lot of the impediment for her to lot of the this thing and all, lot of the using the things thing and only to lot of the drag on the matter and to harass this lot of the appellant herein.
Please come to the, please come to the application.
Before I come, I will take my lords to the one moment. Not of the, I will take not of the, this is the not of the self-acquired property of the plaintiff. Not of, I will show not of the sale deed not of, for a moment.
No, before.
I will come, lords, I will come, lords. That. Not of the page number 55 is the not of the sale deed. Not of, this is dated 35/1962. Not of the plaintiff's, not of the appellant's mother purchased this property in the year 1962, my lord. That my lord, page number 55. 35/1962, my lord, she purchased, my lord, plaintiff's mother purchased. My lord, plaintiff's mother died in the year 1988, my lord.
Yes.
My lord, subsequently after the death, my lord, she inherited this property.
Yes.
My lord, my why, my lord, I am bringing to the knowledge of this honorable court. My lord, either the my lord, the respondent number 1 or the respondent number 2 has no right over the my lord, the self-acquired property of my lord, the plaintiff.
That will be decided.
That my lord, I will come to that. Yes. Even in this matter, my lord, the IA also not.
Please come to the IA. What is that they have filed? We will see that.
Yes, ma'am.
IA.
Application is not page number 25, my lord, sir. Page number.
What is the suit schedule?
Page number
property?
50, my lord.
What
Suit
is
schedule property is not a 3-floor building, not in one of the not of the second floor. She not trespassed. First respondent trespassed into the property and not is sitting over the property.
So she is staying in the first floor.
Second floor.
Second floor.
Second
Where is the plaintiff staying?
Not
Plaintiff.
Plaintiff is not, it is suit schedule property belongs to the plaintiff, not due to harassment.
Belongs to
Yes.
him. Where?
Yes.
In which floor she is residing?
Not I will come before I could come to those things.
Make a
One-
submission.
one
Plaintiff
moment,
is
one
not
minute.
residing in the suit schedule property.
Yes, I do agree, my lords, because due to harassment caused by the my lord, the respondent number 1, my lords, he could not able to stay there. My lords, now he is staying with my lords, her son, Dr. One, my lord, the Chandramouli. My lords, he is there. But the fact is this, my lord, in the year 2000,
Yes, sir.
my lord, the impugned order is, my lord, the
For the impugned order,
application,
please
my
come
lord,
to page number 50.
50, my lord.
Yes.
Page number 50, my lord. 50 is the my lord, the application, what they have
We'll
filed.
look at it. What is that
Yes.
she's asked?
Not for the reason shown to in the accompanying affidavit, defendant number 1 prays that honorable court may be pleased to direct the plaintiff to allow her access to the common areas in the suit schedule property by opening the locks of the common areas, common utilities as listed below in the interest of justice and equity. Not she has mentioned not there are 4 not the roof, terrace building stated so and so, utility areas, basement, some from so and so. Not we have immediately we have filed the objection. Not this application
There
is
is no, there is just, this is the petition. What is the very, there is no affidavit to this?
There
Yes,
is
ma'am.
affidavit. They have not filed. I too have not received a copy. This is the actual application filed before the honorable
the-
trial court, my lords. is accompanied by affidavit.
Sorry, my lords, missing that.
No, this order which is referred to at para number 5 is not questioned by him.
My lords, it's
No, at
the
para
only
number 5, what you say is, this court, after hearing both sides, is pleased to allow the application by the order dated 3/8/2014, directing the plaintiff to allow access to common areas, roof, terrace of the building situated in the fourth floor, utility area, sump area, and common toilet in the basement by opening the
This
lower.
That's not compliant. I think this is the contempt application.
This is the petition, modus against which modus we have
They have not complied with the order till date, my lords.
No, that order is not questioned.
challenge.
That is dated 3/8/2014.
3/8, my
It's
lords,
the
yes, ma'am.
impugned order, my lords.
Impugned
It
order,
is
which
the
is
impugned
challenged in
order.
this petition.
You have questioned the 3/8/2014 order in 2024.
No, my lords.
No, my lords.
3/8/2024 itself, notice she has filed this application.
No, it is wrongly, instead of saying to 3/8/2024, it is typed as 3/8/2014
No,
or what?
IA was filed on 3/7/2024.
Please give it to her. Please tell the court what it is.
Lords, 17/11/2018 is the modus, they have filed the OS. 6/1/2019 is the modus, the order of status quo by the modus, both the parties. Lords, in the year 2023, lords, we have approached lords this honorable court, wherein lords this honorable court directed to lords the speed up the proceeding and lords the finish it up within 6 months. Lords, in the year 2023.
No, she is in occupation of the building.
Yes,
You are
ma'am.
not occupying.
Yes,
You are not
yes,
there.
yes,
You are
ma'am.
not using it.
Yes.
So if she uses a common area,
Lords,
what is your
Lords, there was
difficulty?
an interim order earlier on 6/1/2019 till lords, from that day to up to lord 2024, there was no impediment for her to lord all these things. Now only in the fag end of the stage, lords. Now they
Let's think that it is at the fag end of the stage. What is the difficulty to the mother?
Difficulty is this, my lords.
Is it that she wants to harass her in that way?
No. Difficulty is this, my lords. I may take my lords to the page number 86, my lords, for a moment. What, my lord, they are doing in the my lord of the suit schedule property. Lord, the son of the my lord of the respondent number 1, removing the things, my lord, and my lord, the damaged the property, my lord, glass panes and my lord, the doors and all, my lords. I have produced all those, including CCTV cameras, my lord, his photo could be seen from that. And my lord, if my lordship opened those things, my lord, then my lord, she will remove.
Only these people, everybody is having an access, other people.
No, my lord, first of all, my lord, she is a trespasser. My lord, this is self-acquired property of mother-in-law. Neither my lord, the son nor my lord, his wife has my lord, the right to my lord, over the property. My lord, this property is my lord, in between, dispute is in between the my lord of the respondent number 1 and 2 is my lord, since from December 2007. December 2007, my lord, she left the my lord, the company of my lord, the respondent number 2, and my lord, she residing elsewhere. And my lord, this property is my lord, constructed in the year 2014. My lord, 2014, my lord, she obtained the plan. 2015, she started construction. She my lord, completed the construction, my lord, in the year 2018. My lord, before housewarming ceremony, sir, my lord, she suddenly my lord, they entered into the my lord, the second floor of the house and squat over there. And subsequently, my lord, she filed my lord, the suit seeking my lord, the mandatory injunction to my lord, the
No,
quit and
let's
vacate.
accept all your contentions that the property belongs to you. It's a self-acquired property.
Yes.
Defendant has no right to
Yes.
enter into the property.
Yes, ma'am.
You have filed a suit seeking recovery of your possession. No, till pending, when the suit is pending.
But interim order was there to maintain status quo.
Status quo is what?
Status quo, not then again, not considering this application in the fag end of the stage, not in the, not the final argument. In 1 or 2 days, not the argument will be over. Not at this stage, not considering and not asking him to not the remove the locks and all, not the sump locks and all. Not this at this stage, not if not 2 days, not the argument is finished, not everything will be finished. At this stage, not the order passing the order to not the provide them access. Not if the access is.
Please come to the impugned order.
My lord, interim order. Interim order is page number, not the 14, my lords. Relevant is not the page number 20, my lords.
Yes.
My lords, after this, my lords, allowing this application, she filed not 2 applications. One is contempt and one other is not permit her to break open the locks and all. Not subsequent of not this order. Not the impugned order is not the only page number, not the para number 12, not page number 20. Not wherein not the trial court, not the may I read not the trial court mentioned.
I've read it.
Yes, this is not the when the matter is not the in the fag end of the stage. And not the allowing this application, not the since 2018 to not 24, there was no impediment for not for anything for her. And only not the in the year 2024 filing this application and not the allowing this application and not the and based on that not she has filed not 2 applications. One is contempt and one is not. Not this is the situation. Not my submission to my lord is. Not there was a not the interim order of status quo since not 2019, and moreover, not this honorable court in MFA, not they directed the not the trial court to not the pass the not this order within not the 6 months. Such being the fact, not this taking not this application and not the passing this order and not the without not seeing the earlier order that not the order of status quo. And not permitting her, permitting the not of the respondent number 1 to use the not of the that is only not in the ground floor toilet, and it is meant for not of the plaintiff's use, not for my lord, she is only my lord the second floor, even though she is a trespasser, not a my lord of the tenant, not a my lord of the leaseholder. Nothing is there. Even my lord, if she claims that my lord is a shared household, my lord, she can't be claimed as a shared household because my lord, this property is my lord, she left the company of my lord the second respondent in the year 2007. This property is constructed in the year, started constructed in the year 2014, completed in the year 2018. My lord, April 2018, my lord, she trespassed into the property. And even thereafter, my lord, filed the suit. And my lord, after filing the suit till 2024, there was no impediment. And my lord, the filing of this application, my lord, the allowing my lord at this stage. And my lord, the which my lord, that not only my lord, I have produced the photographs, my lord, showing that my lord, how the son of my lord, the respondent number 1 damaged the my lord, door and my lord, the window panes. And my lord, the taking the my lord, the taking away the things from that my lord, the building and all. It could be seen from the not the photographs of the CCTV. Such being the not the case, not if allowed her to not use the not the common areas, not it will cause not the irreparable not the hardship to the not the appellant herein, because not the if my lords I opened the not the sump and all, she may pollute the water and all, and not the that ground floor not the toilets are situated. Not she is residing in not the second floor. I don't know not what purpose not she needs those things, because not it is my property, not it is not say constructed for my purpose, and not even terrace portion also not so for what purpose not say. Not I don't want to shame not the he is doing not the parties and all, because of that not she wanted not that property in the terrace portion.
Yes.
My lords, the defendant number 1, that is the respondent here in my lords, is the daughter-in-law of the house, and the suit shall property is a matrimonial home. And hence, she has claimed in a written statement, the suit is for mandatory injunction filed by the plaintiff seeking for eviction of the defendant number 1. The defendant number 1 has taken a contention that since it is a matrimonial home and a shared household, and as per the division bench judgment of the Honorable Supreme Court of the year 2021, she can claim a right to reside as per section 17 of the Protection of Women from Domestic Violence Act. The Honorable Supreme Court says, only after leading evidence and only on proof that there is domestic violence and domestic relationship, and it is proved that a shared household, she has a right to reside, and that right has to be decided by the Honorable Civil Court. But meanwhile,
No, right from 2018, you're not using that common areas. So why did you not come up with an application earlier?
so since 2018, they admit I am in possession of the future property or the written statement scheduled property. My lords, there are various complaints filed which is marked even before the Honorable Trial Court, where they have disrupted the electricity, water connection, and I had to live in dark also, and I've approached the BESCOM authorities seeking that please restore the electricity connection because I'm not able to lead day-to-day life. There has been water disruption, and I have gone out from second floor and to fetch even basic for cooking also and drinking also, water purposes also, I had to go out and get the water, my lords. But since now I'm not able to do that because of my health issues, as my with my proceeding age also, I'm in my 40s now, and I'm not able to do that or undergo such sort of effort to get water
Where
or the
did you
basic
say all that?
necessity.
Where did you say all that? That what was the reason for moving an application in 2024, when you're staying in the house from the last 6 years?
Well, those complaints have already been marked.
For this application, there should be a reason when you're moving it in 2024 in a pending suit, being a defendant in the suit. You should say why it is.
I have stated that there has been disruptions, and hence to
To
access
have
for
the
it-
application, where did
for
you read it?
it's not there in my file also, my lords.
What have you passed on?
My lords, that was the contempt application because this order was passed on 3/8/2024, directing the plaintiff number 1 to open the locks within 3 days, which they have not complied with, and hence I was constrained to file a contempt application. Since now there is no water, I mean the water is decreasing day by day. I mean the flow of the water in the kitchen.
So it's not you alone staying. There are 3 floors. You stay in one
There's
floor.
no one else staying in the whole building except me and my minor son. There's no one else in the building.
No, there are
no other occupants.
Ground floor and first floor or
Entire thing is vacant. Entire
it's not
thing is
given. It is not rented out.
I am staying and maintaining the entire property as cleaning, and repairs and everything. That is the reason, my lords, I
Is
sought
it
for
correct that
permission.
first, the ground floor and the
My lords,
other floor is not occupied
Lords,
by
I am
anybody?
I am having photographs, lords, nobody can stay there, lords, such a, lord, the horrible lady she is, lord, she is aged about 84 years appellant. And lord, after lord file, she filed lord in the year 2007, 498 against all the family members. Lords, all the family members also, lords, left this person also, lord, the respondent number 2. He is residing elsewhere. And lord, because lord, the 498 she has filed, lord, in 498 she herself stated that lord, since from 2007 up to 2018, lord, she was in different address. I have produced all those documents before this one. Lord, Lord, this, Lord, aged about 84 years, this lady. Lord, Lord, if she go near that, Lord, if she push it, Lord, she will fall down. That lady, that is the position of her.
Please no.
My lords, my right to possession includes enjoying of whether it is a rightful possession or wrongful possession.
No, there is
Is
no,
yet to be
no,
decided.
no, there is not, no argument on that is required. It is settled that you have to enjoy it. The only query of the court is, why did you not do it from 18 to 24? That's the only query of the.
Well, lords, I went to the extent of going out and getting water. I mean, that is the trouble I've been through. But finally, I'm not able to do it due to my health reasons at this stage. And common
Read with the
amenities
order
becomes a
passed.
necessity, my lords, to any survival.
The
my lords.
orders passed in. Item number 7 and 8, invoice number 8.
Only 7 lords I have challenged. Only 7 I have challenged.
Only
not-
7 you're
Only
challenging.
7. It was a common.
is-
past.
8 is not
To
putting
put
the
up
CCTV camera.
Cameras. Agreed with the orders passed in item number 7, dated 3rd August 2024, and orders number 8286 of 2018. The plaintiff is before this court. The parties are, the plaintiff is the mother-in-law, the defendant, or the son and the daughter-in-law.
Defendant number 2 is the son. Defendant number 1 is the daughter.
Defendant number 1 is the daughter-in-law, and defendant number 1 is the son.
Husband of lord,
Defendant number 1 is the daughter.
Defendant number 1 is the daughter-in-law, 2 is the son.
her husband, lord. Second, first respondent.
So I'm referring to the relief that is sought in the suit is to grant mandatory injunction, directing the defendant to quit, vacate,
My
and
lord.
hand over the vacant portion of the Schedule B property to the plaintiff. The suit is filed in the year 2018.
If I may make a submission, my lords. Now, at this stage, I filed an application to break open the locks, especially of the roof, because the water in the kitchen has decreased substantially, the water flow, to get the repair done, my lords. All the water ducts are either there in the utility area in the basement or on the terrace, for which I have no access. If the water stops tomorrow, my lords, I have absolutely no access to the basic necessity for survival, that is water, my lords.
The suit is filed on 17/11/2018. The court had granted an order of status quo. Thereafter, on 29/5/2024, the matter is posted for final arguments. At that stage, the present applications are filed, that is I number 7 and 8.
7.
2 applications are filed, that is 7 and 8. So IA number 8 is filed to install the CCTV cameras. And IA number 8 is filed for installation of CCTV cameras in the premises. And IA number 7 is filed to direct the plaintiff to allow access to the common areas in the suit scheduled property by opening the locks of the common areas, common utilities. That is, 1, roof, public terrace of the building situated in the 4th floor, 2, utility area in the basement, 3, sump tank in the basement, 4, common toilet in the basement. For that, the objections were filed by the plaintiff stating that now the matter is, the suit itself is going to be disposed of. And at this point of time, only to drag on the proceedings, these kind of applications are filed. the defendant has no right to live in the said property. And the defendant being a trespasser is not entitled for the relief that is sought. According to them, the CCTV cameras are already installed. According to the plaintiff, the CCTV cameras are already installed. The court, by order impugned, had allowed the IA number 7 and 8 filed by the defendant. While allowing the said application, the court observed that the defendant had filed a written statement by way of amendment. She has sought the counterclaim under the provisions of the Protection of Women from Domestic Violence Act, directing the plaintiff from dispersing the defendant number 1 from the B scheduled property. After framing of the issues, the evidence on behalf of the plaintiff as well as defendant number 1 has been concluded. At that stage, the present application is filed. The court observed that there is no dispute about the fact that the son and the daughter-in-law. No, it is son means the
And number 1's minor
grandson.
son, grandsons. He's a school going boy.
1 minute.
That's-
No, defendant number 1 is the
Defendant one, my lord, kindly.
daughter-in-law.
Daughter-in-law. my lord,
Defendant number 2 is her son.
Her, my lord, her husband, my lord. First,
Yes.
first defendant's
That,
husband.
That the defendant number 1 is residing along with her minor son. Admittedly, the plaintiff and the 2 sons are not residing in the property. It is also an admitted fact that the CCTV cameras are installed by the plaintiff, which is in her control. The said CCTV cameras are not access to the said CCTV cameras. The defendant number 1 had no access. It's also not in dispute that the plaintiff has locked common areas, utility areas, such as terrace of the building, sump in the basement, and common toilets in the basement. The photographs produced by the defendant number 1 would show that those areas are locked with the plaintiff. The defendant number 1, who was residing with her son, she has necessarily access to terrace floor for the purpose of cleaning and monitoring water tank and also a dish antenna. The first defendant needs to access the terrace floor so as to maintain the pipes, etc. Utility area and sump area also necessary as she is using the water from the sump. If there is any leakage, damage or leakage, she needs to access those areas. Therefore, the common areas access sought with defendant number 1 is reasonable. The court has also observed that the plaintiff had disputed the right of the defendant to reside in the said building. The court felt that whether she has a right to reside in the said building or not shall be decided by the court during the course of trial. Further, when it comes to the CCTV cameras, the court felt that though the CCTV cameras are installed by the plaintiff and which the defendant has no access, she can install the CCTV cameras. And accordingly, by order impugned, had allowed these applications and permitted the defendant number 1 to access to common areas and directed the plaintiff to open the locks within 3 days from the date of order. And also permitted her to put up CCTV cameras in Schedule A and B properties subject to result of the suit on merits. Next, aggrieved thereby, the plaintiff is before this court. Then counsel for the appellant plaintiff submits that the suit scheduled property is a property purchased by the mother of the plaintiff. And it is not a joint family property, or it cannot be termed as it's not a joint family property. And it is an exclusive property belonging to the plaintiff. He submits that the daughter-in-law cannot have any right in the said property. He submits that the suit is filed in the year 2018. And in 2019, there is an order of status quo. In the MFA, there is an order by this court to dispose of the suit as expeditiously as possible. He submits that only to drag on the proceedings, the present application is filed. It is stated that the matter is posted for final arguments on 29/5/2024. At that point of time, this application came to be filed. He submits that the son of defendant number 1 is in fact damaging the property, and she cannot seek for such a relief as granted by the court at this fag end, that too, she being a trespasser. He submitted that the application, the appeal is liable to be allowed by setting aside the order passed by the trial court. Next, then counsel appearing for the respondent defendant submits that she is residing in the second floor of the building, and the first floor and the ground floor are vacant. There is nobody is occupying the said building, and the plaintiff is residing with her son. When she is residing in the said building, and whether her entitlement to the property or whether she can retain her possession has to be decided by the trial court after a full-fledged trial. And this till the suit is disposed of and an order is passed by the court, she is entitled to use she is entitled to have access to all the common areas and facilities. It is submitted that she has been put to a lot of inconvenience and hardship by the plaintiff, where the power connection the power supply is disconnected. And she had failed. She has been facing problems with the water supply. Now the sump is also logged by the plaintiff. It is submitted that in this rainy season, if there is no access to the defendant to reach the terrace, and because of the leakage and other issues, it will be difficult for her to stay in the building. She has been facing all these hardships from a long time. And in fact, she has been getting the water from outside. Now, in view of her, in view of the health, her health conditions, she is not in a position to do the things as she was doing all these years. As such, she has filed an application before the court. Then counsel submits that by allowing these applications, no prejudice is caused to the plaintiff, as the plaintiff is not residing in the said building. It is submitted that the order passed with the trial court is a well-considered one, and that the MFA is liable to be dismissed. Next, having heard the counsels on either side, produce the material on record. The undisputed facts are that the defendant is staying in the second floor of the building. It is the case of the plaintiff that she is the owner of the property. The property is purchased by her mother, and later she acquired the said property, and she has constructed a house. And the defendant number 1, who is none other than her daughter-in-law, had trespassed into the property. She has no right. She has no right to live she has no right to the said property, and she had filed the present suit seeking a prayer of mandatory injunction directing the daughter-in-law to quit, vacate, and hand over the vacant portion of the Schedule B property to the plaintiff. It is also an admitted fact that that the plaintiff is not residing in the said building. She's staying along with the son. According to the daughter-in-law, it's a matrimonial home. And she has every right to reside in the said building. And she had also filed a counterclaim in the suit filed by the plaintiff. Now, the trial court, after a full-fledged trial, has to decide who is, whether the defendant has any right to live in the said property, whether the defendant is a trespasser, and whether the plaintiff is entitled for the relief as sought for in the plaint. There is no, as rightly contended by the land counsel for the appellant, this application is filed at the fag end of the trial. It's when the suit is of the year 2018, that application is filed in the year 2024. Just because the application is filed at the fag end of the trial, that itself cannot be a ground for the court to dismiss the application. As long as the defendant is staying in the said premises, she has to have the access to all the common areas and to all the utilities. Now, by granting any of the, by allowing these applications, no prejudice would be caused to the plaintiff, as the plaintiff is not residing in the building. When once the court comes to the conclusion that the defendant is not entitled, and the other steps would be followed. But as long as she is in occupation of the property exclusively in the second floor, she needs to have the access to all the common amenities. In view of the disputes between the mother-in-law and the daughter-in-law, she cannot log it cannot be said that by granting access to the basic, to the common areas, that a prejudice is caused to the plaintiff. This court is not able to appreciate the contentions raised on behalf of the plaintiff, appellant plaintiff, and in the considered opinion of this court, the trial court had rightly allowed the applications, and this court finds no reasons to interfere. Accordingly, appeal is dismissed.
My lords, one submission. I'm not very sure, but while dictating, my lords, probably undisputed facts, it is stated as defendant number one is a trespasser, which is not.
No, I
the
didn't
case.
say that. Trespasser is not undisputed. Undisputed fact is that, yeah, you are staying there.
Much obliged.
How it can be, how you will say that you are a trespasser? Yes.
Number one, say number two, E. Balakrishna Shastri, for appellant.
Appellant, please. Not the
Yes.
order of the Leonard City Civil Judge, my lord.
My lords, if I may be allowed to read one paragraph of the order of the Lord of the lower court, my lords. It's at page number 36 and 37, my lords.
First of all, how a suit is maintainable when already the surface proceedings are initiated by the
Lords,
appellant?
we were
When
alleging.
you're saying fraud,
Yes.
just to, come within the bracket of the Honorable Apex Court judgment, where did you say? Let's see your plaint. What is the fraud that you are pleading? Let's see that.
Page 39 onwards.
Page
plaint.
number?
Page 39 onwards, plaint.
Where is that paragraph with regard to the fraud, allegations of fraud?
My lords, I think para number 8, 9 and 10, my lords.
Paragraph number 8, 9 and 10. Please read.
It is submitted that the defendant number one has sanctioned the loan for 4 crore 80 lakhs to the plaintiff number two with an interest rate of 15% per annum. A copy of the sanction letter dated so-and-so is produced as so-and-so. It is pertinent to mention that even before the sanction letter was issued, defendant number one insisted that the plaintiff number two had to execute a mortgage deed. Accordingly, a memorandum of deposit or title deed dated so-and-so was executed in favor of defendant number one. The aforesaid memorandum of deposit or title deed was registered as document number so-and-so, recorded in so-and-so before the sub-register. A copy of the said memorandum is produced. the mortgage was created with respect to Schedule B property. A perusal of the memorandum of deposit or title deed dated so and so show that the mortgage was land and not the flats. It is further relevant to submit that the defendant number 2 is the absolute owner of Schedule B property and she had signed the mortgage deed as a guarantor. The loan was sanctioned to the plaintiff so and so and is marked as so and so. The plaintiff number 2 submits that there is no mortgage in favor of the defendant number 1
So
with
this, this is a fraud. 8, 9 and 10 is a fraud.
My lords, further, my lords,
Hmm.
further, my lords.
No, come to that relevant where you have alleged fraud. Fraud,
My lords, in 15, my lords, in paragraph 15,
yes.
a perusal of the demand notice would go to show that the bank has played a fraud in issuing and publishing demand notice.
What is fraud in that?
My lords, so what has happened is, my lords, we had taken a loan on a Schedule A property, which is a site, my lords, on which,
But is, if
on-
when the surface proceedings are initiated,
yes, my lords.
it is not something which the court cannot, before the appropriate forum, it cannot be decided, that it has to be decided by the trial court.
My lordships, on this particular site, certain apartments have been built. There is no plan sanction for this apartment. There is no kata for this apartment. Nothing is as of date. It is not yet a completed apartment. It is 90% done. The final touches have to be done, my lords. My lords, in the demand notice, if you see, my lordships, in
If there
the,
is something wrong with the demand notice, that is not a fraud.
my lordships,
No, it
I'm
is.
I'm coming clean to my lordship's hands. my lords.
The process of the court and you filed, you have taken loan in the year 2014.
Yes, my lords.
2024, now when is the suit filed in 2024?
Yes, my
Till such time you have not realized.
My lords, the demand notice was
When
issued
were
only in
not the
2020.
demand notice, before that, even before the surface proceedings are initiated, there was a, as you were submitting?
There was an award, my lord, on 19/7/2018
That is by the
for
cooperative
recovery
society, my
of
lords.
Have you
6 crore,
My
6
lords,
crore.
my lords, even today, I am not questioning that I have to pay the amount. I'm not saying I don't have, I have to pay the amount.
Then
And I'm
why are you
willing-
filing the suit?
My lords, I am willing to, my lords, if my lordships may see the operative portion of the order of the IA, my lord.
Whatever it is, if you are willing to pay, that's not a charity or some benefit you are doing
Of
to
course
the
not,
bank.
of course not, my
You
lords.
have to pay the amount.
Of course
No,
not.
the same can be done when the surface proceedings are pending or before the forum which has jurisdiction, you can tell that I'm ready for a settlement.
My lords,
that
the
I want to
DRT will
settle for-
not, my lords, the DRT will not entertain what I am willing to propose right now, my lordships. My lordships, there are 6 apartments in the site and there are about, I think, 20 sites in the agricultural land which we have pledged. There are two-
Whatever is the settlement, because you want to settle and DRT do not allow you,
Yes,
that will not give a cause of action for you to file a suit.
if my, I think lordships may consider this one submission, my lords. Even today, my lords, we are willing to sell the apartments. Let the bank take the first right on the lien, which is, I think, coming from the, sorry, which is, I think, coming from the sale of the property. Let the bank itself be a party to the sale deed. Let them take the money which is coming from the sale of these apartments, sale of these sites first, until their amount, whatever they are claiming here, has been settled. For that, I'm willing to file a joint memo or compromise petition, whatever it is, my lords, today. My lords, what we require is, my lords, we require a no objection certificate from the bank for individual apartments to sell the property, my lords. My lords, the site, my lords, it is a Sadashiv Nagar, my lords. It is a 5,600 square feet site, my lords. Each apartment will fetch a good amount of money. If the bank is permitted to sell this particular site by themselves, it will not fetch good money and we will also be put to great loss and hardship, my lords. My only submission is that there are 6 apartments, there are 20 sites. You sell each apartment, you sell each site until your loan amount has been cleared today. You are claiming 24 crores. Okay, I admit that we have to pay 24 crores with interest, penal interest, whatever it is. I am willing to go to the extent of even supporting you and finding you buyers, my lords. We have buyers also ready, my lords. We are in the construction business for a long time. We have purchasers ready. We want the purchasers to come, let them issue, let them be a part of the sale deed.
That does not stand all throughout.
No,
There's
no.
My lords,
No, please. wait.
please, sorry.
No, he is ready. No, whatever that, the apartment that they have sold. Now, even if you take this surface proceedings further, you have to sell the property.
That's true.
That's the only thing
That is
to recover the amount, the
That's-
loan amount that they have taken.
That's,
So what do you say about this proposal he's saying?
my lord, the trial court has stated so 6 months ago. Till now, my lord, Neither he has,
We'll ask them.
neither he has come nor he has sold anything,
No, no, no.
nor he has paid any
No, no, no,
amount.
by Tuesday,
Ah.
whatever he is submitting before the court,
Ah,
let him come up with an affidavit and with all the
Please.
relevant particulars.
Ah.
Then what you want is, you don't want his property to be sold, you want your money back.
That's right, absolutely right. Now, my lord, question is, if he wants, my lord, to sell any one particular flat, let us say, he has a customer for good sum of money. No bank, let alone myself, we will not obstruct him at all because we are interested in money. Now look at, my lord, these facts. We gave 5/11/2014, 5 crores. 12/11/2014, 4 crore, 8 lakhs, 80 lakhs. Then NPA in the year
No,
2015.
no, what we will do is,
Ah.
we'll do like this.
18 million
According to
awards
you,
came
no,
to
no.
be passed.
According to you, he has
Now,
been,
we are in 2024. Court bill has passed, my lord, judgment 6 months ago.
My lords, for the
Asking
past
him
10 years,
to come
they
to
have,
me,
they have put interest. I'm not.
sell it. But
no, no, whatever, now the settlement would be, you will be, you are also, entitled for the interest. Calculating everything, let them come up with
Yes,
some
Lord.
proposal. If it happens, ultimately
That's
you
it.
should
No, no.
recover the money.
No,
Come up with that. File an
absolutely
affidavit.
no difficulty.
Pose this matter on Tuesday, when?
On Tuesday, my lords, as my lordship says, we will
No,
come
no,
up with an
today is
affidavit.
Monday. I thought like.
Next Tuesday, I thought. my
No,
lords.
no, no, before by this weekend, Thursday.
On Thursday, my lords.
Pose this matter on Thursday at the request of learned counsel for the respondent plaintiff. By the time, he shall file an affidavit and the terms of settlement and give a copy in advance to the counsel for
Please, my
the,
lords. Please, my lords.
but the appellant defendant, yes.
Obliged, my lords.
For the respondents is appear for the
Huh.
petitioner.
Why is it adjourned on the last occasion?
Lordship ordered for calling for report with regard to the signature of the conciliator.
Hmm.
In the order sheet, I have produced certified copy wherein
Court
there
is
was.
placed. What is the office note on that?
In the cost list, it is reported that the report is received. And the learned registrar has made a report.
Yes. It's just a, communication gap or the mistake of the concerned copies from a section of the,
But
what they say.
my lord, I have the certified copy. One of the grounds raised on the basis of the certified copy, your lordship may kindly peruse. Signature of the conciliatory is blank.
No, that's what, as he said, generally they will obtain that later. Even when you filed a application for the
Copy application.
certified copy, without the verifying that the process is not complete, they have given you the copy.
Yes, my lord. If that is so, if that is the report is in that aspect, my lord, your lordship will kindly see, it appears on the particular day, there was no lokaat constituted. If it is said that the signature was not taken, your lordship may kindly peruse the order sheet, the order
What do you say on that? That according to him, there was no Lok Adalat on that day.
It was held, my lord. It's done in the taluk committee level. It's done on daily basis in the municipal courts.
No, it cannot be.
And any party,
Cannot
at
be.
any day, they
There is
can
a-
approach the court and say that.
How will you know now whether there was any Lok Adalat on that particular day or not?
My lord, the court will be on regular session.
No. How it is maintained? How, if we have to just look back and see whether on a particular day it was done or not, how do we know? How do you know? Even if we call for any information, how we will have it? They must be maintained.
There must be some proceeding maintained.
No, here, my lord, what happens? Practically, to imagine,
There will be some proceeding maintained with regard to the Lok Adalat.
Whole problem, according to them, that is not there.
And one lordship will kindly see this
This for
order
Lok
sheet,
Adalat held on 22/12/2015.
this proceeding itself is illegal. There is a direct decision on this aspect.
We will not go here and there. The first and foremost aspect is about this, that
Exactly.
you are saying that there is no Lok Adalat
No,
on
no
that day.
Lokaat.
My
And
lord,
thereafter-
one thing, my lord. in
thereafter
this
I have
aspect,
filed an application.
if my friend permits me, I'll just submit, it's very relevant to be considered. This particular contention that no Lok Adalat was held and it was not signed by the advocate conciliator, it is taken for the first time before this honorable court. Whereas in the application which she filed seeking for recalling that order, accepting the award, my lord. In that
Where
application,
is that application?
nowhere it is
No, no,
stated so.
That application.
My lord,
Application, my
But,
lord, it is,
it is at
Annexure L, my-
page
annexure.
94, my lord.
Annexure L.
Page 94. And same thing she has reiterated in her chief evidence, which is at page 96, my lord.
That's in Kannada.
That's in Kannada, my lord.
What she says, she doesn't say anything at page 94 about that day, about no
No,
Lok
my lord.
Adalat
No,
on
she
that
had-
day.
Absolutely, she
She
doesn't
has
say.
no,
She only
she has
says.
stated, she has no idea. There was one
No, no,
person
no. I'll
sitting.
just, Nalla,
There
ನಾನು
was one
ತಪ್ಪಿದ್ರೆ
person,
ಹೇಳಿ
I will file translated copy. There was one,
Many times the court will stand on this case.
no, not that.
How many reports to be called
No,
for?
no. On the face of it, my lord, there's a decision, direct decision on the point.
That
You
is-
may kindly see.
Now that is only whether 226 is maintainable or.
Yes, sir, certain.
It is maintainable.
Yes, yes.
It is maintainable. There is no
Maintainable.
dispute on
No,
that.
no, Lordship may kindly peruse this judgment directly on the point, without going to further details.
Now, first of all, we have to be clear on the factual aspect.
No,
Then
no.
we'll go to the legal aspect.
No.
No, the factual aspect itself is not clear now.
With great respect, my lord, on the face of the records, this is the order sheet of the court. Order sheet of the court cannot be used for local, that's the decision, on the point, honorable Supreme Court decision, as well as this honorable court decision. Lordship may kindly-
Take that.
Paragraph 9,
When is that order?
please, Your Honor.
That order, even assuming that such an order which you are denying, when is it passed?
That is, my lord,
22/12/2015.
page 89,
212?
page 89.
22/12/2015.
When is this filed? This writ petition is filed?
In 2017.
I filed an application before the same court. That was rejected and thereafter I have filed
Let's see your application before the same court.
Exactly.
same court. That is, my lord,
Page number.
94, my lord.
annexure L, page
Application is
94.
filed in Kannada.
I
Yes,
will
my lord.
file
Where
a
they have
translated.
filed it in Kannada before the.
I will file translated copy. But my
You
lord,
don't have to, even before the trial court, you don't have to file the papers in English?
No, my lord. Here in Mafasil areas,
Kannada
allow
version,
the.
Kannada version. Usually Kannada versions are filed in the Mapshil.
For us in Andhra and Telangana, it has to be, every document of the court should be in English.
No,
No Telugu, there won't be that.
Mapshil court, Mapshil court,
Official
the-
courts also, everywhere, only the evidence is recorded in Telugu. And that will be translated on by the judicial officer.
my lord,
And by the
I
time
will,
it comes to the high court, we look at the English evidence only.
but here, even evidence is also in the Kannada. in
No,
the
it
Map-
is in Kannada, but the judicial officer will translate it into English.
No, that is not.
So what will happen is, it will be taken and it will be translated. Like whatever
Not
if the
not
witness
in
is saying in Telugu, then she'll be dictating it in English, whatever it is. Then they will verify and then sign it. Or no, what will happen is it's a difficulty now.
But here the civil rules of practice
Lordship
permit the
may-
Mafasil areas.
Lordship may permit me
File
to
it in
file
the-
translated copy, but even without that, my lord, I'm only requesting
So
you, lord.
first of all, what are the grounds that are taken before the trial court? You cannot keep on
Yes.
improving your case from one court to the
No,
other.
no, 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 I am
So
not
first you
improving.
have to know,
No, no.
in this page number 94, what did you say?
You-
What was your case?
No, before that, my lord.
And as well 96, my lord. The
Lordship-
chief affidavit what she
Uh,
filed.
94, the counsel for the
One
the
submission, your
petitioner,
lordship may
one
kindly.
minute. Counsel of the petition shall find the translated copy of page number 94 and 96. Next part, the registrar judicial is directed to find out whether on, what is the date?
22/12/2007, 2015. 22/12/2015.
22/12/2015, whether any Lok Adalat was held. Which court is this?
Second,
Second additional.
second
civil judge
additional
and
civil
JMFC.
judge, junior division and JMFC, second court at Hassan.
Please write it on a paper.
And
So and so.
annexure K, it is there.
Yes. Pose this matter on 23rd September. Yes, next.
Bill number 5. Vanita N for petitioner.
Yes.
For the petition,
You wanted a notice to be issued in this,
stay.
seeking enhancement.
No, minor. To stay the proceedings because this is the matter where the petitioner has filed. Petitioner is the.
When is, impugned order is passed when?
15/7/23. And she's
Impugned order was passed on 11/7/2022. How can it be?
25/7/23, madam. Annexure A.
Yes, the order is at page 21. An order that is passed on which year? That year also not to be seen from this order.
11/7/22, madam.
Why you should be stayed now? It can't be stayed. Notice to the respondents. Petition is permitted to take out notice from the council appearing for the respondent for the trial court.
No, it's not in the Bangalore, madam. It's in the Malur, Ola district.
So then notice to the
RPAD on.
notice to the respondents. Issue emergent notice to the respondent and the petitioner shall pay the process. Yes, pose this matter on 14th of October. Yes, 6.
Okay, for the petition, my lord.
P. Natagaraj.
Petition filed by the husband, my lord. Husband is challenging the application filed by the wife before the trial court, my lord. On the ground of the jurisdiction, my lord. Impugned order is, my lord, page number 70, my lord.
Where is impugned order?
Page number 70, my lord.
Yes.
The relevant portion is, my lord.
It's a
21.
permanent alimony of 2 crores. You are saying
Madam.
jurisdiction.
My lord, initially, my lord, facts of the case, my lord, husband has filed a divorce petition, my lord, in the year 2009, my lord.
That was allowed, my lord. Thereafter, wife filed a MFA before this honorable court, my lord. This honorable court has set aside.
Come back again. What did you say? Initially,
Initially, husband has filed a divorce petition in the year 2009, my lord.
2009.
My lord. MC number 26 of 2009
Uh,
was allowed by the trial court, my lord.
where it was filed?
Before the Monday, my lord.
Mandya.
Monday, my lord.
It was allowed.
Allowed, my lord. Thereafter, wife filed a MFA before this honorable court, my lord. MFA number 7100 of 2000. 7100 of 2014, my lord.
710014. What happened to that?
This honorable court has allowed the petition and set aside the divorce granted by the trial court, my lord. Thereafter, my lord, husband has filed a SLP before the Supreme Court, my lord. Supreme Court allowed the petition filed by the husband, my lord, and granted 20 lakhs rupees interim permanent alimony, my lord. Permanent alimony.
Allowed on when? SLP is allowed on?
Allowed on 22, my lord.
20?
23/11/2022, my lord.
23/11/2022.
Yes, my lord. And granted liberty to the wife to file a application under section 25 of the Act, my lord. In the meantime, my lord, wife also filed a MC petition 2470 of 2016 for restitution of conjugal rights, my lord, during the pendency of the SLP, my lord. That was allowed, my lord. Husband has not challenged.
Restitution is MC?
MC number 2470 of 2016, my lord.
7016. When was it allowed?
My lord, allowed on in the year 2022.
Was it not brought to the notice of the Apex Court?
Apex Court also, notice was brought to the notice of the Apex Court, my lord. Apex Court, my lord, thereafter has given the liberty to the respondent wife, my lord, to file an application under section 25 of the Act to taking permanent alimony as a sought against the my lord. Only come to the my lord, page number.
Yes, what is the present order?
My lord. The wife has filed the miscellaneous petition, my lord, before the family court, Bangalore, my lord. I filed objection that, my lord, there is no jurisdiction to challenge that, file the application before the family court, Mysore, my lord. Initially, I filed a MC petition before the Monday court, my lord. Before the Supreme Court, my lord, the Supreme Court has given liberty in that petition, my lord, to file a application to seeking for permanent alimony. In respect of not before filing the Monday court, my lord, they have filed the Bangalore court, my lord. That is, has been challenged before this.
Please read the order.
This. Page number 70, my lord, MP number. This is petition filed by the petitioner under section 25 of the Indian Marriage Act, seeking for permanent alimony of rupees 2 crore. The respondent raised an objection regarding the jurisdiction of the court, claiming that all the properties referred by the petitioner are outside the jurisdiction of the court. The records placed before the court shows that the petitioner wife filed the petition under section 9 of the Indian Marriage Act in MC number so and so before this court. The respondent has not disputed the jurisdiction of the court in MC number 2430 of 2016. The respondent admittedly filed the petition in MC number 26 of 2009 before the Principal Senior Civil Judge Mandya under section so and so. The records placed before the court show that petitioner wife prepared an appeal before the Honorable High Court of Karnataka in MFA number so and so against the judgment and decree passed in MC number 26 of 2009. The Honorable High Court of Karnataka, the order dated so and so, allowed the appeal filed by the petitioner wife and set aside the judgment and decree passed in MC number so and so. Principal Civil Judge, the respondent approached this Supreme Court of India in civil appeal number 8824 of 22 against judgment and order passed by the Honorable High Court of Karnataka in MFA number so and so. Honorable Supreme
You
Court of
contested that restitution of conjugal rights petition which is filed by her.
my lord, that was allowed, my lord. Thereafter, my lord, before the Supreme Court, my lord, brought to the note of the Supreme Court, my lord, the wife also
What
not.
is that order of the Supreme Court?
Page number 40, my lord. 11% is, my lord, page number 42, my lord. Para number 6, my lord.
So what is the difficulty if it is decided here in Bangalore?
Madam, the MC, Honorable Supreme Court challenging the
No,
appeal, madam, MC
you
number.
filed MC
Yes,
in
madam.
Mandya.
Yes,
He filed MC in Bangalore
Madam.
for restitution of conjugal
Yes, madam.
rights. Sir. No, nothing is pending. The moment you paid 3 lakh rupees, sir, it is done.
Madam, we already deposited at 20 lakh before the Monday court, madam.
It is now lying there.
Yes, madam, Monday court, madam. But madam, we are filed a MC petition in the year 2009 in Monday court, madam. Before the apex court, madam.
The notice to the respondent.
The stay of the, madam, now the petition evidence is going on in a criminal mispetition.
Notice to the respondents. When counsel the petitioner submits that in the divorce proceedings that are initiated by the husband in the courts at Mandya, when the matter was carried to the Honorable Apex Court, Honorable Apex Court has permitted the wife to file an application seeking permanent alimony, and it has to be filed before the courts at before the family court at Mandya, but not at the court at but the courts at Bangalore do not have jurisdiction. Considering the submission, there shall be stay of all further proceedings in so and so, so and so. So and so till the next date of hearing. Pose this matter on 24th. The petitioner, the counsel of the petitioner shall serve a copy of the, shall serve the notice. The counsel appearing for the respondent by 13th of September. And to that effect, a memo shall be filed shall be placed before the court. If the memo is not filed, the order granted by the court stands vacated without further reference to the court. Yes.
7. S.R. Sripal.
The short question is whether a will can be executed pending proceedings.
Whether a
will can be executed pending proceedings. Not the trial court says will cannot be executed pending proceedings, contrary to the division bench judgment of this honor.
Please come to the order.
Please.
See the order.
Starts at Lord page number 13. Relevant
This is a
court.
suit for
Lord, first respondent filed a suit for partition. First respondent herein. Lord, suit is dismissed. Then Lord, she files the regular appeal. She filed the suit against father and brothers and sisters. In the appeal, Lord, I filed filed the application on Rod 41 Rule 27 to introduce the will executed by my father. That application is dismissed on the ground that it amounts to transfer of property. I'll just take Lord to page number 18, paragraph 8. Since the alleged registered will dated 15/7/2011 is a document executed during the pendency of litigation, same is hit by the principles of doctrine of lease payment. This is all the observation.
no,
On the
whether
point,
the final judgment is passed.
final judgment is also not passed.
No, it has to be decided when an
Along with the
application is
merits.
made under
Please,
41/27.
please. That is one of the grounds that in the writ petition. She dismisses and posts the matter for argument. It must be considered along with main. That is number the first submission. Second, my lord, the court cannot say will cannot be executed.
Agreed with the orders passed in IA number, what is IA?
Lord, IA,
Agreed with the orders passed by the appellate court.
IA number 3.
Agreed by the orders passed in IA number 3. Where do you get that impugned order?
Page number 16 is the relevant portion.
Agreed with the orders passed in IA number 3 and RA number 15 of 2023, dated 24th July 2024, whereby an application filed by the appellant here, filed by the petitioner, defendant or
Different respondents. Respondents 2 to 4 filed the
by the respondents 4 to 5 under order 41 rule 27 came to be dismissed. Then counsel submits that when an application is filed under order 41 rule 27, the same has to be decided by the court while passing the judgment, but not at this stage. He submits that the court has held that during pendency of the proceedings, the will cannot be executed. He submits that such a finding of the court is contrary to the settled law. and he relies on a division bench judgment of this court in,
Lord, I have.
pass on,
ILR 2001 Karnataka 3466.
give the copy.
Please.
Take that, in case of so-and-so, reported in so-and-so, considering the submission of the council, there shall be stay of all further proceedings in RA number 15 of 2023 dated 24 July 2024 till the next date of hearing. The council is permitted to take out notice on the council appearing for the respondents herein before the appellate court and file a memo to that effect by 13th of September. Post this matter on 24th September. If the memo is not filed, the stay granted by this court will stand vacated without further reference to the court.
Emergent notice.
Yes,
Emergent notice. Note, emergent notice.
hand summons.
Please. Right.
Wherever I say personal notice, it's hand summons. Yes, next.
I appear for respondent. My lord, kindly grant 10 days time to file joint memo, my lord. I will prepare the joint memo, my lord. Send
Do
it
it. For how many days it will be pending like this?
my lord.
Pose this matter at the request of both the parties on 18th of September. No further adjournments will be granted.
Oblige, my lord.
Yes, next. What is this criminal petition?
Criminal petition is filed challenging the section 22 order of the DV Act in which the petitioners was directed to pay the ex parte interim maintenance money.
Pay for a short accommodation in this matter. We are awaiting certain instructions from our client with regard to.
Any urgency for you?
No, they are seeking time from past weeks, my lord.
They're taking time from past?
Past several dates, my lord.
Let's see that. Where is the docket?
The wife has committed the adultery, my lord. Wife has committed the adultery.
Now pending consideration. Respondent prays for time on 19/8/2024. Only one time?
In connected case, my lord.
Oh, pose this matter on, no further adjournments.
Unless one petition has
Request of
entered.
counsel for the
Respondent.
respondent, no, counsel for the petitioner in WP 13976 of 2023.
Both the writ petitions, my lord.
Once, because just to know that, ensure that it is petitioner. Pose this matter on 12th of September. No further adjournments will be granted. Yes, next.
Till number 10,
Yes.
till number 10. Appearing for the respondent, my lord, there's talks of settlement going on, so can the matter be posted for next week?
It is submitted with the council appearing for the respondent that the settlement talks are going on. Pose this matter on 18th of September. Yes.
Much obliged.
Well,
Number 11 adjourned, till number 12.
I appear for the appellant.
for the respondent.
Adinath.
I have a copy. Hold the copy and.
Why is it adjourned on the last occasion?
For me to file this compilation.
Hmm.
Of all the documents filed by the parties before the trial court.
Served a copy on her?
Just now, my lord.
Yeah.
My lord, the appellant, my lord,
It's served just now.
Just now, it's okay, my lord. Your lordship can continue.
Yes.
the appellant, my lord,
Please, let's see, tell the facts of the case.
my lord, the appellant.
Hmm.
The appellants, my lord, are. My lord, my kind.
No, if it takes some time, we'll have it at 2:30. It's better, so that we'll complete the other list. Please, call it at 2:30.
Till number 13. Chandra Chudiye, for appellant. Prasad.
Respondent. Engage senior counsel in this matter. Engage senior counsel in this matter, may be passed.
Fast road. Yes.
14. Till number 14, Kashinath JD, for appellant.
You appear for the.
I am
respondent?
state, my.
Appearing for state.
Stay is there in this? Stay.
Stay, no stay is there.
No, it's there, it seems. This my interim order granted earlier. No representation on behalf of the appellant. Pose this matter for dismissal on 19th of September. Yes, next.
Cell number 15. Cell number 15.
Lords, I appear for appellants, my lords, I have served copies on the parties, my lords, instead of serving on advocate. I was under the impression that I should serve the copies on, as the hand summons was ordered.
Petitioner is permitted to serve the hand summons, petition from take out hand summons on the counsel appearing for the respondent before the trial court. And shall, was it served?
My lords, for others, it has been served, my lords.
On the council, pose this matter on 10th of September?
Yes, my lords.
Yes.
Much obliged.
Cell number 16.
Lords, I'm apologized, my lords. Serial number 14, my lords. I'm aware for the appellant. My lords. Kindly,
It's already adjourned.
it's for dismissal, it is mentioned. I have.
Same day at the request.
Interim order medical.
Interim order earlier granted is extended till then.
Cell number 16. Rajashekar S.
If
Appellant.
that's the respondent is in. Contesting respondent has entered caveat.
You have to show copies on him.
Suit for declaration. Pass on.
Also,
My lords, I have one submission. Suit is one for declaration. That is a suit. The caveator is the plaintiff and we are defendant number 3. My lords, appellant is a purchaser of the property who purchased it from defendant number 2 during pendency.
yes,
And my lords, during,
he's asking for a password.
I just want to make only one submission.
No, whatever it is, it has to be heard. No order will be passed without hearing them. Pass over.
Rest.
Cell number 17. Cell number 18.
Appearing for the respondent, my lord, senior counsel is in another court, kindly pass over.
How many passwords? When the court will hear all these passwords? Yes, 19 passover, yes, 18 passover.
20.
What about 19?
9.
This is 19.
Yes, Prasanna Kumar.
For representation, 19. Poses matter
Objection.
for dismissal.
Objection is
Huh?
objection statement is here.
What is that?
Objection statement.
You're filing the objection, filing the secretary. No representation on behalf of the appellant, post for dismissal on 19th of September. Yes,
28.
28.
20.
20.
Yes,
Same.
same, same matter, same, yes.
Cell number 21.
21 also.
This also same. Yes, 22.
22.
Yes. Yes,
The appellant has filed a PNDC provided before the PDJ court before Chikkballapura. The appellant is the granddaughter of the one Madama.
Hmm.
She was executed a will on 22/2026. The Madama was expired on 25/3/2026. After lapse of 18 years, when the appellant had been to the native place, she found that the will was executed by the grandmother. So thereafter, when she has inquired before the witnesses, unfortunately, witness number 11, Hussain Saab, was also expired in the said will. Thereafter, she has approached the second witness by name S. Nanjundappa. He has stated that in his presence only the will was executed. So thereafter, she has approached the Tahsildar to make a khata in her name. The Tahsildar, instead of issuing the khata, they are told that go get the court and obtain the probate. Since she has filed a PNDC before the PDJ court and she has also examined as a PW1 and marked the document from exhibit P1 to P13. Thereafter, the PW2, the Nanjundappa, was also examined on behalf of the appellant. The trial court was rejected the PNDC on the ground that the PW2 was present at the time of execution of the will and the stamp paper was purchased in Bangalore MG Road. at about 10 o'clock. And he has, PW2 has stated that the will was executed 10:30 AM in the native place. It's a created doubt to the court. It was rejected. Your Lordship might kindly appreciate.
No, why is it a created doubt? No.
Has created document.
No. The will is executed about 18 years back.
18 years back.
Now we are seeking the probate.
Yes.
No, the will is, no, according to where is the place where it is executed?
See, as per the PW2, he has stated that it was executed in his native place.
Where is it?
That is in Chintamani Taluk, Chikbalapur district from the
Chikbalapur
Chikbalapur
district. How
district.
much time it takes from here to there?
It will minimum 80 kilometers from Bangalore.
Hmm.
It will take minimum 1.5 or 2 hours.
Hmm.
Lordship might kindly appreciate. There is no rival claimant in this property. Since 2018 years back, it was executed. No property was claimed by any person. Even filing the
No, when you are coming before the court, seeking a relief, court has to grant on the basis of what the material before it, not because that there is no rival party in this.
correct, man. See,
Otherwise, if there is no rival party, enjoy it. Why do you want it?
see,
from the
after
court?
lapse of 18 years, when the court was put a question to the PW2, that is the witness to the will.
Place of where the will is executed, I don't think that is such a complicated question for the witness.
So that is the reason the court will put a question to the PW2 after lapse of
Bound by it.
18 years from the date.
What to do? You have come after 18 years. You have come to the court after 18 years. What the court can do?
See, even I will get the copy only for the will after 18 years I found. Then only I approach the court. Or otherwise I am not aware since the appellant is deciding.
Whatever is the procedure to be followed for proving that, the court has to follow.
No matter what happens, is after 18 years of the execution of the will, the
No,
witnesses
the
is
problem
unable,
is-
the witnesses is unable.
No, now you say that there are no opponents, there is no dispute. Then why do you require this?
But based on the will, you see, I cannot go for get the property for Qatar or change in my name. That is the problem. So after 18 years of the execution of the will, the witness is unable to remember the date and time. So unfortunately, what happened, PW1,
There is a date on the will.
there is a date is there.
And
But-
now where is it executed is also not in dispute. Because
that-
that person, that grandmother or grandfather of yours is staying in that.
Native
village.
place only.
Now,
Okay.
where is this document, the stamp papers are?
Stamp paper was purchased in Bangalore. See,
But
that's
that,
clear.
it is not about memory, it's all clear facts.
No, that is after lapse of 18 years, nobody can.
No, I'm saying it is not basing on your memory, it is on basing on the dates, no.
The date of stamp paper, it was purchased.
The stamp paper is clear, for that you don't require any memory, that will, that the date is born out of it. And where it has executed, the will contains it. So
Correct.
what is the distance between that and this? When is it executed? That creates any amount of doubt in the mind of the court.
That evidence was conducted after lapse of 18 years, the PW1.
What I'm saying, it is not about the memory. It is already there on paper, where
Already
it
there
is
in the paper.
executed, when it is purchased. Even if PW2 doesn't say about it, but it remains, the fact remains is at Chikbalapur, it is executed will,
It's native place.
native place.
Native place.
It is purchased here on the same, no, if it has to be taken, at Bangalore.
No, even as per the exhibit even produced by the appellant, my lord, even the notary was executed in Bangalore.
Hmm.
That also the trial court is holding that is a created doubt, because your lordship kindly appreciate after lapse of 18 years from the date of filing of the P&S.
I'm saying if something depends upon the memory of the witnesses, that is a different aspect. It is not on the memory of the witnesses. These are all the things born out of some document. For that, you don't have to remember also. After 18 years or 30 years remains to be the same. That nobody can change it. Court was right.
I'll call for the records at least, my kind, last time we will peruse the records.
Why should it be when there is no point? Notice, call for the trial court record. No notice.
God bless.
Please directed to call for the lower court records. Yes.
23 for the respondent.
Opinion for petitioner in this matter, my lord. Kindly pass over the matter for filing the assets and liability.
Yes, pass over. Next.
24. 24.
No representation for dismissal on 24th of September. Yes, next.
Bill number 25 adjourned. 26.
Appearing for petitioner, kindly pass over the matter, my lordship. Senior is on.
Huh?
Kindly pass over the
One more?
matter.
Pass over.
Cell number 27. Keshav M.
No representation. On behalf of both the parties, post this matter on November 11th.
28 to 30 adjourned. 31. Arun Govindan.
I appear for the petitioner in this case, my lords.
Yes.
My lords, the mediation is in progress, my lords, but the thing is this, my lords. Admittedly, my lords, the salary, my lords, is 18,000 of the wife. The take-home salary of the respondent is 2.2 lakhs. 49,000, my lords, is the EMI, my
No
lords.
representation on behalf of the respondents. Pose this matter on 14th of, on 11th of September.
Please.
Cell number 32. Cell number 32. Venkatesh Somareddy. BS.
Same for both the matters, no representation for dismissal on September 30th.
Cell for dismissal, cell number 33. Jagraj B.
Petition in the above case.
Yes, Sarvana.
Last
Yes.
occasion, both the parties have filed the affidavit, your lord. She is a doctor. Court has insisted to file the affidavit whether she is have the source of income or not, your lord. She filed the affidavit saying that she is not having source of income and all, your lord.
Why it is
If-
adjourned on the last occasion?
Other side was not there, request of time, your lord. In the counter, I also filed affidavit saying that she is also working, your lord. Kindly,
Then counsel for the petition seeks time submitted, the same is informed to the other side.
before that, your lord. Kindly, along with the affidavit of some of the documents I have placed before the court, your lord. On 12 August, I filed the affidavit before this honorable.
No representation for the respondent, and counsel for the petition is present. Pose this matter on 10th of September,
11th of 12.
11th of September. Yes,
For hearing on interlocutor application 34. Nanjunda Swami N.
32, my lord, kindly.
Kindly pass it. Manmohan. Kindly pass it, my senior.
what the court has to do in the forenoon, if all the matters are passed over, pass over.
My lord, serial number 32, my lord, kindly pass over, my
Huh?
lord. Serial number 32, my lord.
That's I appeared for
Senior
the,
counsel.
that's pass or my lords, I was stuck up in other court, my lords.
32 pass over. Yes,
Cell number 35. Muralidhar HM, petitioner.
no representation for both the parties, post for dismissal on 23rd of September. Yes,
Cell number 36. PP Appaya. Gautam Raghunath.
Appearing for respondent, kindly pass over.
Christian.
Kindly pass over, senior on the.
pass over.
Thank you.
Yes.
Passed
In any of the passed over matters, anybody is ready?
Number 34. Appeal by the Union of India,
Cell number, sir.
13.
1479.
But this is a challenge,
Serial number 13.
13, my lord. It is MFA 1479 of 2024. Uh,
Prasad.
Lord, there was a suit filed against the Union of India. It is a defense land. There was some relief sought against Union of India and the Defense Estate Office. On merits, the suit came to be dismissed. Thereafter, there was a challenge before this honorable court and matter was remitted. After the matter was remitted, Lord, the trial court receives the file. Lord, the LCR is available.
Yes.
Would your lordship kindly, madam, LCR ಕೊಡ್ತೀರಾ? Order sheet. Huh?
Original suit ಬಂದಿಲ್ಲ.
Original suit ಬಂದಿಲ್ಲ.
LCR original suit.
ಇದು original suit ಹೌದಾ?
There is there.
ಅಲ್ಲ OS ದು LCR ಬಂದಿದ್ಯಾ? ಅಥವಾ ಬರೀ miscellaneous ಬಂದಿದ್ಯಾ? We may need LCR of the-
Exhibit P2 is the order sheet. In the original suit after it was remanded. Correct.
But ಇದೊಂದೇ ತಾನೇ original, ಬಾಕಿದೆಲ್ಲ ಇದು. Okay. Anyway, my lord, in the original suit, on 1610, the entry office notice received certified copy of the order in RFA
545/2001 dated 31st day of July 2008 from Honorable High Court of Karnataka with a direction to dispose of the matter within 6 months from the date of receipt of the copy. Copy is received, hence put up for orders. And then the court order is case called out
This is when the one which you're reading is dated?
16/10/2008. Lord, this is 2008, yes. And then there is a court order dated 2011/2008 issuing court notice to parties and their counsel. Lord, after the remand, the court is informing the parties that now matter has come back from the court, you have to continue the proceedings. That, my lord, the service of this particular notice, my lord, is what is under cloud now. There are two parties. The first defendant was the Defense Estate Office. All the defense lands are held by an officer called as the Defense Estate Officer. The individual army units do not hold them. The defendant number 2 is Union of India, Ministry of Defense. Now, miscellaneous. Now, my lord, please have a look at the order sheet of the miscellaneous proceedings. I'm sorry. Oh, I'm sorry. It is in the, Lord, we may need the order sheet of the original suit.
No. Now the original suit was decreed when?
No, it was dismissed.
It was dismissed when?
Lord, I'll furnish the list of dates. 24/3/2001.
24/3.
2001.
Filed by?
In OS number 7613 of 1992.
1992 suit.
Yes, my lord. And against this, the plaintiff Raghava Reddy files RFA 545 of 2001. 545 of 2001. And which is allowed on 31/7/2008 and remitted back to the trial court for fresh disposal after giving opportunity to both sides to adduce their evidence.
So the defendants are aware of this order,
Yes,
this
yes.
remand of the
Yes,
matter.
we were aware of the remand. It was received on 16/10/2008 in the trial court, and the court issued notice on 2011/2008. I'm sorry. On the same day, that is 16/10/2008, the court issues notice to be returnable by 2011/2008.
Yes.
To both parties, that is plaintiff as well as defendant. And then, my lord, the office note dated 2011/2008, it says, court notice to plaintiff number 2 returned, served on person. Now, what is important is, then, my lord, the second part. Court notice to defendant 1 returned, served on the office. My lord, we tried to see, my lord, the original file. We have not, the office notice, defendant, court notice to defendant 1 returned. If it is returned, under what circumstances does the court hold that it is served? Lord, there is absolutely no explanation to that. It says court notice to defendant 1 returned, then served on office. If it is returned, it can't be deemed. If I refuse to receive, then it can be deemed service. If it is returned, then it has to be reissued. And nobody from the office of the first defendant has received.
Yes. Then what happened?
And then as far as defendant number 2, Union of India was concerned, Lord, the plaintiff took paper publication.
In my 17/12/2008.
Yes.
17/12/2008. Case called out adjourned anta ide 17/12.
Notice was served on advocate of appellants, order 3 rule.
Yes.
And here, my lord, in Union of India, what happens is, the copies are typically, if it is High Court, the copies are served here in the office of the ASG, then it is nominated to Central Government Council. Not as on today, there are about 100+ central government council. Any new petition comes, I nominate it, and then it is dispatched by the branch office. In every city, major city, there is a branch office of the Ministry of Law. They typically send an email saying that you have so-and-so, you have been nominated, because they're all private practitioners. Other than me, everybody else is a private practitioner who are called upon to handle the matters on behalf of the Union of India. So when a matter is closed and then it is revived, there has to be a fresh nomination, whether the same council is there or not. There is a long gap of time. So
What happened when the suit is decreed?
then what suit is decreed, I'll furnish that. So by placing both of us, that is the DO and the Union of India ex parte, the suit was decreed on 22/1/2010.
20th.
20th January, ಇಲ್ಲ sir, 22 ಅಂತ correct. And in the judgment, my lord, I am shown as absent. D1, D2 is shown as absent. Lord, these are all defense lands. Lord,
When did you file an application?
the miscellaneous application, my lord? Date, could it? Date of filing the miscellaneous application. 9/13. ಈ synopsis ಅಲ್ಲಿರಲ್ಲ, it will be in the synopsis. Twenty-five 2024. My lord, after the decree was, the suit was decreed, since we were unaware of the proceedings before the trial court, nothing happened. We were completely oblivious of that. When the plaintiff started putting up some construction, my lord, that's when we got alerted, and then we had to follow the entire procedure.
When is the date?
My lord, it was filed on, date of filing, 5/1/2013.
2013.
2013.
Hmm.
Lord, that is in MA number,
Miscellaneous.
sorry, miscellaneous case number 23/13.
23 of 13.
13.
What happened to that?
Well, that has been dismissed now, which is why I am before your lordship. By the impugned order, my miscellaneous application has been dismissed.
But when was it dismissed?
My lord, that is on 25th September 2023.
It took 10 years to decide this application.
But unfortunately, it is
That's
just
what I was asking, like, there must be.
the court recorded evidence. I mean, a lot of delay has taken place in disposing of an application, a simple application.
Please come to the order.
Order 9, Rule 13.
Where is the order? Impugned.
Lord, at page 24. Lord, the gist of the case, or rather the reasons are found at page 32. Admittedly, lordship got para 6, my lord. Para 6. Admittedly, this is a case of miscellaneous case by defendant so and so so and so. Gist of the case of the petitioner, originally suit in so and so filed by respondent against this is all the history which we can skip. My lord, para 8. On perusal of the material placed on record, to substantiate the claim of the petitioner narrated above, Sri so and so subdivisional officer, petitioner number 1, entered into witness box as PW1 and filed affidavit in lieu of examination in chief as PW1. All the petition averments are reiterated in his own statement in chief. In support of the petition claim, he has produced 4 documents which were marked as P1 to P4. P1 is authorization letter dated so and so to PW1 defense estate officer to adduce evidence on behalf of petitioner number 1 in the above petition. P2 is the certified copy of the order sheet in the OS. P3 and P4 are judgment and decree in the suit. On the other hand, to disprove the petitioner's claims, so and so, the first respondent herein entered into witness box as RW1, filed sworn statement, affidavit of examination in chief, under which all averments of his written objection to petitioner are reiterated. Copy of judgment was marked as so and so. This court gone through exhibit P2 in the order sheet. Lord, this is very relevant. Dated 2011-2008, there is an office note that court notice to plaintiff 1 and 2 served on person and court notice to defendant served on office. Lord, this is wrong. Lord, this served on the defendant office is wrong. Lord, is this produced anywhere?
This is
Hello.
exhibit two. This is
Exhibit P2 is have you produced it here?
This is exhibit P2.
My lord, would your lordship take exhibit P2, my lord, for a moment?
1 minute, let's complete this order
Yeah,
and
yes.
then we'll go back to that.
Look, should I read from any particular part, my lord? I'm sorry. Shall I read from where I left, my lord?
Yes.
The para 10, the fourth line,
From 13, you can read.
13. Para 13. Therefore, though there is a direction for disposal within 6 months from the date of receipt of the order, even though the same counsel appeared in trial court and appellate court, even after service of notice, has not come forward to appear before the court to assist the court for speedy disposal. Thereafter also, this court directed the plaintiff to take step against D2. On 24/3/2009, counsel for plaintiff produced newspaper publication for substituted service of summons to D2 as per order dated so-and-so on IA filed by plaintiff under 5 Rule 20. Then again, matter posted to 13/4/2009 for appearance of defendant 2, but on 13/4/2009, defendant 2 was absent and hence this court opined that defendant number 2, Union of India, and the summons published in the newspaper is not sufficient and directed to take fresh steps. The said direction was duly complied by the plaintiff and notice was sent to the defendant number 2 through RPD, which was not returned. After 1 month from the date of RPD, the court directed the office to place complaint with postal authorities and obtain necessary endorsement with regard to delivery of postal cover to defendant number 2 and posted for appearance of D2. As per order sheet dated 26/8/2009, the postal acknowledgement due returned to the court, which does not receipt of the same to which official and on what date the seal is not legible.
I've seen that, I've seen that. I've seen that.
Yes. So,
Yes.
my lord, the primarily, my lord, the court come to a conclusion that it proceeds on the office note. Now, please have a look at the office note, exhibit P2. ಅದು ಎಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ?
ಇಲ್ಲಿಂದ ರಿಮೈಂಡರ್.
ಅಲ್ಲ, P2 ಎಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ? ಅಲ್ಲ, P2 is the whole document, ಅಲ್ಲ?
ಇಲ್ಲಿಂದ relevant.
In exhibit P2, my lord, would your lordship kindly turn to the date bearing as 16/10/2008.
Remind back.
2008.
ನನಗೆ I wanted to know where P2 begins on that. It begins from here.
Yes. P2 in
This bunch is P2.
the order sheet. Entire.
Madam, ಅದು order sheet 16/10 order sheet ಕೊಡಿ. ಅದರಲ್ಲಿ P2 in OS 7613. 92 ಅದರಲ್ಲಿ order sheet dated 16/10/2008. But if your lordships are looking at 16/10/2008, Lord, that is the date of receipt. 16/10/2008. Lordship got 16/10/2008, my lord,
Yes.
at the bottom.
No,
And
no,
now kindly turn to the next page.
it's 11, not 10.
Or kindly turn to 2011/2008. 2011/2008.
But 2011 is
Yes,
there.
ma'am. I may read, my lord, this is exactly what para 10, the learned judge noted there. Now, what does 2011 note say? C bar N is court notice. Court notice to plaintiff number 2 returned, served on person. Okay, that is done. Then next one. Court notice to defendant 1 returned, served on office. Lord, what does this mean? Which, if it is returned, then it should have been reissued. It says served on office. So which office, who received it? Is there a seal? Is there any documentary evidence of that? But here, if you look at para 10, in the impugned order, the court says, this court gone through exhibit P2, in the order sheet dated 2011/2008, there is an office note that
Before
court,
going into that, now according to the plaintiff, his owner of the property,
he claims, yes, ma'am.
and you deny his title to the property,
Yes.
saying that it is a defense
Yes, yes,
property.
yes, yes.
Now, yes, Mr. Senior Counsel, why not a chance be given to them to contest the matter?
And if
Because it's
a
clear
time period may
dispute
be
of-
fixed, I will not take adjournment.
dispute of title to the property. They are claiming title, you are also claiming title to the property, and it is a suit for bare injunction.
Yes. But,
Uh,
how many times the court should try to?
I'm sorry
bring
about
them
that.
Before the court.
That's only, I think, after return. this
No,
is-
no, 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 no.
Even prior to that.
Yes, paper publication was given
No, after the matter is remanded, you're telling about this.
Yes, after the.
No, I
matter
was
was
unaware of
remanded,
it. Simple fact
he
is.
never attend. And their witness says that he was aware of the proceedings of the remand.
Because
How
they have
many times?
contested it.
No, the point is, even if they are government of India, they are equal with everybody. All the parties are equal before this honorable court. Kindly see the impugned order. How the learned judge has tried to bring them before. Kindly see. It is not returned. When the court says returned, kindly, I will verify the record. That means the acknowledge came back. Acknowledge came back, nobody appeared.
So when that ex parte judgment and decree is passed, what was the appreciation by the trial?
That is on the merits.
What was it? Was it?
My records,
Hmm.
my documents. The property is a private property, not now, from 1923. I have placed all the records before the court. All the records, original documents. I am not claiming some property which does not belong to me.
No,
On the contrary, they have placed no record whatsoever to show that they are the owners. Except in the register and entry, somewhere that they are the owners. That is not the title deed. On merits, the court has given the correct judgment.
So in the light of the judgment of the apex court in Anathula Sudhakar's case, when there is a serious dispute with regard to the title of the property,
Yes.
so whether a bare suit for injunction is maintainable or not, is the issue which has to be gone into
No,
by
the court has gone into the title also.
No,
Court
no,
has gone into the
bare
title.
suit for injunction, whether it is maintainable when the defendants are seriously disputing the title of the plaintiff.
Yes.
In Anathula Sudhakar's case, Honorable Apex Court said, in such a situation, bare suit is not maintainable. Suit for injunction. Necessarily, the plaintiff has to seek a
No, it is.
declaration.
Where-
No, why
But
am I saying all that is-
I have not taken advantage of their absence in the second time when the matter was remanded to the trial court. The court has appreciated all the records that I have submitted and my evidence and has given a judgment.
No, we'll do.
And in the meanwhile, no, I will take this honorable court to through various documents. It is, no concession need be shown to the government of India. How many times the court has made its best efforts to get them before the court? How many times? On the first day itself, it is all borne out from records. Oh, everything is borne out from records. Kindly see paragraph number 10. What the learned judge says.
Yes.
One or two paragraphs.
Yes,
Paragraph 10 P35.
yes.
This court has gone through exhibit P2. Exhibit P2 is the order sheet. In the order sheet, the exhibit P1 is written, it is wrong, P2, dated 2011-2008. There is an office note that the court notice to plaintiff number 1 and 2 served on person, and the court notice to defendant served on office.
Yes.
Served on office. After calling out the defendant number 1, his absence was recorded in the order sheet, and the
No.
court gave direction to
Fine,
plaintiff
the
to take
entire
steps against defendant
service of
number
summons
2.
and also will be there.
Here,
Just see in this, whether the service of summons are also there in the.
everything is there. I will demonstrate. I have checked all.
From the record I'm asking.
Yes. Then to continue.
Yes.
No, your lordship wants to verify that first.
No, you can continue.
Pass.
In the meantime, she will see.
Yeah. So, 1, 2, 3, 4. Fifth line and from the bottom. Here it is important to note that in verification portion, in the pleading of this petition, it is verified by A. Bhaskar Reddy, the defense estate officer, that he is also representing the second petitioner, but there is no authorization produced by the petitioners to show the authority of the first petitioner to file this petition on behalf of petition number 2. The exhibit P1 is the authorization issued by the defense estate officer. the petition number 1 to PW1. And in this document, it is specifically noted that PW1 is authorized. Let us forget about the
It's all
authorization.
not necessary.
That is
come.
not necessary.
Then come,
Then,
come
no,
to
no,
this
then-
bottom portion, some Kannada extraction is there. What is that? What is pertaining to what?
That is Nanu ಮತ್ತು that is by PW1. ನಾನು ಮತ್ತು ಒಂದನೇ ಅರ್ಜಿದಾರರು ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಬರೆಸಲು ಮಾಹಿತಿಯನ್ನು ಕೊಟ್ಟಿರುತ್ತೇವೆ. ಒಂದನೇ ಅರ್ಜಿದಾರರು ನಮ್ಮ ಆಸ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟ ದಾಖಲಾತಿಗಳನ್ನು ಇರುತ್ತಾರೆ. ನಾನು ಮತ್ತು ಮುಖ್ಯ ವಿಚಾರಣೆಗೆ ಒಂದನೇ ಅರ್ಜಿದಾರರ ಪರವಾಗಿ ಸಲ್ಲಿಸಿರುತ್ತಾನೆ. ಎರಡನೇ, that is also with regard to the authority. Let us
No, that after remand in the OS.
that
Yes.
Kannada portion, that is the authority, let us ignore it. Let us
Yes.
assume that.
Next
Then paragraph
paragraph.
11. As on 17/2/2008, the next calling date in exhibit P2, that may be read as exhibit P2. There is an office note stating that the court notice to advocate for defendants returned, put up with the file. In this regard, this court has gone through the cross-examination of PW1, not the plaintiff, PW1 in the petition.
Yes.
PW1, and in page number 10, PW1 has admitted that ನನಗೆ ಮೂಲದ I will give the English translation to your version. ನನಗೆ ಮೂಲ ದಾವೆಯ ಆರ್ಡರ್ ಶೀಟ್ CP ನಿಶಾನೆ P ಎರಡರಲ್ಲಿ ಏನು ಬರೆದಿದೆ ಎಂದು ನನಗೆ ಗೊತ್ತು. He says that he is aware of what is written in exhibit P2, that is the order sheet in the original suit. ಅರ್ಜಿದಾರರಿಗೆ ಕೂಡ ಮೂಲ ದಾವೆಯಲ್ಲಿ ಮತ್ತು ಹೈಕೋರ್ಟ್ನವರ ಮೂಲ ದಾವೆಯನ್ನು 7 ತಿಂಗಳ ಒಳಗೆ ತೀರ್ಮಾನ ಮಾಡಬೇಕು ಎಂದು ಕೋರ್ಟ್ಗೆ ನಿರ್ದೇಶಿಸಿದರು ಎನ್ನುವುದು ನಿಜ. It is true that the suit had to be remanded, suit had to be tried and decided within 7 months. ಹೈಕೋರ್ಟ್ನ ಆದೇಶ ಆದ ನಂತರ ನಾವು ಮೂಲ ದಾವೆಯ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿರುವುದಿಲ್ಲ. After the High Court remanded the matter, we have not examined the matter. ಸಾಕ್ಷಿಗೆ ಈಗ ಮಾನ್ಯ ಹೈಕೋರ್ಟ್ನ ಆದೇಶದ ನಕಲನ್ನು ತೋರಿಸಿದಾಗ ಸಾಕ್ಷಿ ಅದನ್ನು ಒಪ್ಪಿಕೊಂಡು ನಿಶಾನೆ R1 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. After the matter was remanded, they say that they have not examined the order sheet of the trial court. Then ನಕಲನ್ನು ತೋರಿಸಿದ ಸಾಕ್ಷಿಗೆ ಈಗ ಮಾನ್ಯ ಹೈಕೋರ್ಟ್ನ ಆದೇಶದ ನಕಲನ್ನು ತೋರಿಸಿದಾಗ ಸಾಕ್ಷಿಯು ಅದನ್ನು ಒಪ್ಪಿಕೊಂಡಿದ್ದು ನಿಶಾನೆ R1 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. And in the
Senior
same
counsel,
page.
No, the entire order I've gone through. No, as per the order, RFA, when the matter was remanded, they are aware of the remand and they have to appear before the trial court and about a pending suit. That they have not, that they have not verified nor about what is happening to the suit. Then coming to the notices, according to the learned counsel appearing for the Union of India, that returned is interpreted in a manner how he is doing. And according to you, the return is the acknowledgement has come.
Correct, it is there. It is
Where?
there. It is on record.
That there also it is written as returned. What is that return? We don't know.
No,
That-
then
that-
again, the notice has been
No,
directed.
for that, why can't we have that, why can't, no, that's also accept that, that is served on them.
Registered post is also served. Registered
Both on
post is
respond, defendant number 1 and defendant number 2.
Yes. Registered post served.
No.
Then
there
can they say
definitely-
that?
No, definitely there is a difference between an individual and an institution.
No. Then my constitutional rights are going to be affected against the government.
No, why in some cases?
Let us see 913, he must demonstrate that he had no notice, he had no summons. Can they say that, can the court go and serve the notice on them? Even substituted service has been directed. If I were to be in their position, what will happen? This appeal will be dismissed because you had notice.
No, but the courts are also considering even individuals, these kind of lapses also in the interest of substantial.
No.
It's not alone about Union of India. Even if it is in
Union
this
of-
case, any other individual is there, because the valuable rights in the property.
And in the
on
meanwhile-
some terms, we will do it, on some terms.
And in the meanwhile, what they have done is, They have put, there was an injunction against them, temporary injunction. In violation of that order, they have put up a fence around my property.
Not be material.
No, now why not material? It is. You have done it. No, if you are going to argue on merits, we will argue. I will continue. Let us see how the order passed by the learned judge is effective or is not considered. You have received the notice. It doesn't lie in the mouth of the government of India to come and say we had no notice.
No, we have not received it. That's my.
Why- let us see
The
the
order
record.
sheet bears,
I
order
will
sheet
see
shows
the
that it is
record.
returned.
1 minute.
I will
Uh,
see the record.
The registrar judicial, please come. The registrar is the registrar judicial is directed to play to call for the record of the trial court pertaining to the summons to defendant number 1 and defendant number 2, and the said copy shall be placed before the court.
Records are not.
It is not there. It is only miscellaneous application.
I think records had been.
You can have it. No, or else give it to them.
Let the original suit come. Your lordship.
Under OS 7613.
OS 76.
Yes.
13 of 1992.
I will demonstrate before.
Shall be the notices that are served on the trial court record with regard to the summons that are served on the defendant number 1 and 2 shall be placed before the court.
Entire records may be called for. Entire thing.
Entire record of.
Entire records in the original.
No, let's say after the remand. Why from the beginning?
That will continue. There is a continuation.
Entire record pertaining to OS number so and so shall be placed before this court. Post this matter on when?
Next week, my lord, 9th, because it's a.
It's record ಬರ್ಬೇಕಲ್ಲ.
In Bangalore, but they can fetch it.
Not on 9th, we'll have it on 17th. Post on 17th.
Very well, 17.
This also.
My lord, I have one
19.
submission with
Yeah.
regard to the date.
19.
19th, your lordship.
19th. Yes.
Pass over matters. Serial numbers. Pass over.
Serial number
20.
23.
Serial number 23.
Appealing for petitioner in this matter, my lord.
Pass over
Yes.
matters.
Filing assets and liabilities of petitioner.
Where is the counsel for the
Babu
respondent?
TC. For respondent.
I have served a copy on them. I have served a copy on them.
No, ma'am. They are not arrived.
Then you have to serve it and file. At least let them be
Exactly.
there in the afternoon. When they are there, let him. Yes, any other matter who are ready? Passed over matter?
Next one, passed over matters.
No, on the other side also should be there.
18.
Senior seems to be not there since morning, maybe a short date, maybe then, yes. I'm sick.
They said that they asked for a passover.
They asked for.
Ina PK.
I have been
Let's
here.
see, yes. Any other matter where both the
Afternoon.
parties are ready in a passed over cases? Yes.
Afternoon,
Serial number 27, my apology, I was withheld in 23, my lord. My lord, the thing is, I want a week's time because
It's already adjourned.
Okay, we have not get the instruction from the
It's
petition.
already adjourned.
Okay.
27, what has happened? Yes.
Great,
Yes.
sir.
First matter, my lord.
Hmm?
41 matter.
Hmm.
Adali, I have served the copy on the other side. 41, my lord.
That is at 2:30 we will take up, not now.
2:30.
So they are all 2:30 matters. No representation on behalf of both sides. In one she wrote, the other she didn't. In this she wrote.
That side is.
Which matter?
Serial number 26.
Hmm. Just call that matter.
26, ma'am.
26.
Bill number 26.
Appearing for the petition, my lord. My lord,
Now, my lord, he has filed my lord the assets and liability affidavit.
1 minute. As for the order passed, the petitioner has not filed a statement of assets and liabilities before both this matter. And by the time the statement of, so you have filed it now.
file.
Filed it, my lord, income, that is income, because my lord the 3 years, my lord the account statement he has to give, only 1 year.
Not filed. He has not filed.
He has only 1 year he has filed, or 2 bank account, but I have filed application also, my lord, 340 application.
Now he has filed an application stating that we have separate
Yeah, but-
meetings. The
Why
petitioner.
don't you file all those statement of assets and liabilities means as per the judgment of the apex court in Rajneesh versus Neha. Whatever he said that you file. You file a complete one.
And
The-
may I request?
the-
10,000, not because there was non-availability of document, my lordship has passed my lord 10,000. Even though trial court, my lord's interim order 25,000 was made. Lords, even assets and liability now filed. My lord, my lord, the salary shown is my lord 2,20,000 per month. Not taking into consideration, my lord, other, apart from my lord, the other aspects of the matter.
No,
Yeah.
we'll pass a final order itself. Let him come up next week. Pose this matter on 13th of, not 13th, pose this matter on 11th of September. By the time, 11th of September, before that, the land counsel for the petition has filed the statement of assets and liabilities. Land counsel for the respondent submits that they are not in consonance with the judgment passed by the apex court. He shall file all the documents as per the law laid down by the apex court in Rajneesh versus Neha, post on that 11th of September. On the day, the orders will be passed finally. Yes.
Bill number? Bill number 16.
Both the sides were there?
Please.
Both sides.
16, yes.
Please, man. Apologies, my lord.
Yes.
Please. That's why before I start my submission and merits of the case. Now, my lords, I have one submission. Suit, my lords, is filed by my lords of the cavator, which is one for declaration. And in 2018, my client has purchased, apparently, my lord, during pendency of the proceedings. That is during pendency of the injunction application. My lord, without filing written statement, my lords, the application is disposed of. I gone through the records. Now my client has put up construction which they are well aware of, and it's almost first floor is complete. My client is putting up a school. He wants to shift the school. Those facts, my lords, have not been placed on record, and written statement is also not placed. Now, my lords, let the order which is under challenge before this honorable court, let operative portion be intact. My lords, my humble submission would be, my lords, I may be permitted while be filing my written statement. The injunction application, my lords, may kindly be considered afresh by the trial court or my lords by your lordships. That's my humble submission.
May I place your 22 submissions before your lordship?
No, he's a subsequent purchaser.
Please.
He has not filed his written statement,
I'll-
nor his objections to
I'll-
your
I'll just
application.
place certain materials before your lordship.
Not material. No, what?
Two lines, my lords.
Yes.
Not take more than that. Suit was filed in the year 2014 as against the challenge to the sale deed executed by defendant number 1 in favor of defendant number 2. That sale deed was in 2014. Immediately, the plaintiff, who is the owner of the property, filed a suit for declaration saying that the sale deed is null and void. Thereafter, my lords, they enter appearance. That is D1 and D2 enter appearance. They contest the suit for 3 years. In 2017, my lords, after they filing the written statement, 2018, the sale deed happens. That is from different number 2 to different number 3. Now, my lords, different number 3, my lords, thereafter he also files enters appearance. He has not filed his written statement till date. Now what happened is, then he starts putting up the constructions. In that time, my lords, because all this time the suit schedule property was vacant. Now, since he started constructing the suit schedule premises, we said that we file an application under 39 Rule 1.
No, that's why what he says is, whatever is the interim order that his trial court has passed, let it be there. Now, once after he files his
Let him
objections,
give an undertaking of status quo, my lords.
you're not understanding, he says that this order can be continued.
Please.
That's what he's saying.
Then-
He says this order passed by the trial court, let it be sustained.
Please.
And let him be permitted to file his application, bringing all the facts, then the trial court can consider the injunction petition again,
Please,
afresh.
please.
Yes, please come. Agreed with the orders passed in IA number 7 and OS number 1499 of 2015 dated 20th February 2024. The defendant, who is a subsequent purchaser, is before this court. The suit is filed seeking declaration and permanent
Please,
injunction
my lords.
against defendants number 1 and
1
2.
and 2. 3 was subsequently.
1 and 2. During the pendency of the said injunction and the pendency of the suit, the D2 has alienated the property in favor of D3.
Three.
And now the present IA came to be filed stating that the defendant number 3 is putting up construction and they sought for an injunction. The plaintiff has sought for an injunction restraining the defendant from raising the structures. Then an order was passed restraining the defendant number 3 from putting up construction in the suit property till disposal of the suit. When the matter came up today for admission, for admission, land counsel appearing for the defendant number 3 submits that he had no opportunity to put forth his case before the trial court, and there was no occasion for the trial court to consider the case of the defendant number 3 and granted injunction. He submits that the defendant may be, defendant number 3, who is the appellant hearing, may be permitted to file his written statement and his objections to the IA.
He has filed objections to the application. He contested the application.
Then
Objection is filed, my lords, and in the fit of my lords urgency, which the other side were, my lords were stressed the application. Written statement was not filed. All the materials were not placed.
he
in the-
submitted that as in the urgency, all the true facts were not brought, all the facts were not brought to the notice of the court. Hence, an opportunity may be given to the defendant to file his objections and also a written statement. Thereafter, the court may consider the application of the plaintiff, that is IA number 7, afresh, till such time there can be an order directing the order of injunction, that is the injunction restraining the defendant number 3 appellant hearing, putting up the construction in the suit property may be continued. Land counsel for the plaintiff submits that he has no objection for such an order, considering the submission on behalf of both the parties. The order impugned dated passed in IA number 7 is set aside. Just listen to that, what the court is saying. Unless and until it is set aside, how can another application be decided? The order passed by the court, by the trial court in IA number 7 is set aside, and the matter is remanded to the trial court. The defendant is at liberty to file his, defendant number 3 is at liberty to file his written statement and all the relevant and his objections to IA number 7. And on such, and after filing all that, the court shall consider the consider IA number 7 afresh. Next, number 3. Till the said application is decided by the trial court, there shall be an injunction restraining the appellant from putting up any construction.
My lords, one submission, my lords, I'm producing. Let it be at this stage itself. My lords. I'm producing photographs. My lords may kindly consider this, not sort of.
Yeah,
As-
give him also.
Let it be at this stage itself, ma'am.
Learn counsel, look at it.
Yeah.
Yes, Mr. Counsel.
Please.
Learn counsel for the.
Not
defend-
any internal.
Learn counsel for the defendant number 3 had filed the photographs before this court stating that now they have laid the pillars for the second floor.
Please. Please.
They have
They have
filed the
raised,
photographs.
constructed only the
before-
first floor.
Filed the,
not second floor.
no, filed the photographs before this court. Now, the said photographs are taken on record and the learned counsel for the plaintiff also submits that. That is the construction put forth so far. So there shall not be any further constructions. Yes.
No, this shall not come in a way for them to claim equities on this ground.
No,
No,
no.
no,
yes,
which
that
we will
be
never-
there.
which
Now, anyhow, IA number 7 is still yet to be
Please,
decided.
Please.
My lords say, ground and first floor, my lords, may kindly. Tomorrow.
Photographs. Photographs, I said this is taken on record. Along with the record, the photographs that are filed before this court shall be sent to the trial court.
By memo dated 2/9/2020.
Yes, by memo dated 2/9,
2023.
yes,
24, sorry.
My lords,
24, yes.
My lords, trial court has got some time constraints, especially for this.
After
matter.
filing after filing all the necessary application, the trial court shall decide IA number 7 within a period of 3 months from the date of filing all the relevant documents before the court.
Say 1 month. 1 month. Injunction.
3 months, yes, next. Now, if this case is admitted, it will not come up for the next 3 years. Yes,
Fast hours.
yes. Serial number? 20? Ready?
Ready, my lord.
Copy received.
No, you're ready?
No, my lords, we have just received the assets and liability
Huh?
copy. We have received the assets and liability copy.
Filing and
today,
assets
my
and
lord.
liabilities.
So, we shall continue in the next, we'll do our argument.
Today, then counsel for the petition has filed the statement of assets and liabilities as per the order passed by the court. Then counsel appearing for the respondent submits that they'll file their objections, post this matter on 18th of September.
Yes, my lord.
Yes. Yes, next.
Next, passed over.
Anybody is ready in passed over matters?
Ready.
Yours is a passed over.
There are two.
Who appeared for the other side?
Here number 32. 34.
Yes, we'll take it up after lunch. No signatures?
My lords. Serial number 27, my lords.
Yes.
I just seek a week's accommodation, my lords, because the petitioner has to make some submissions before this court.
It's already adjourned to 11.
Grateful, grateful.
ಇದು ಬರ್ಬಿಟ್ಟಿದ್ಯಾ ಆಲ್ರೆಡಿ ಸೈನ್ ಆಗುತ್ತಾ ಸಿಎಲ್ ನಂಬರ್ 27 ಅಲ್ಲಿ ಅಟ್ ರಿಕ್ವೆಸ್ಟ್ ಅಂತ ಮಾಡೋ ಅದೇ ಸಿಗ್ನೇಚರ್ ಆಗೋಗಿದೆ ಹಲೋ ಸರ್ ಕೇಶವ್ ದಾತಾರ್ ಹಲೋ
ಹಲೋ
ಸರ್ ಇನ್ ಯುವರ್ ಮ್ಯಾಟರ್ ಕೇಶವ್ ದಾತಾರ್
ಅಲ್ಲಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 31.
No, I am asking that Keshav Datar in serial number 27. ಅವರು ಪಿಟ್ಟೆ ಆಗ್ಬಿಟ್ಟು
ಅವ್ರ ಬಿಟ್ರು ಸೀರಿಯಲ್ ನಂಬರ್ 31 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಮೇಡಮ್.
This matter that no representation ಅಂತ ಆಗಿದೆ because it is order sheet is already signed.
ಅವರು ಬಂದಿರ್ಲಿಲ್ವಾ?
ನಿಮ್
Hello?
31 ಹೋಗಿದೆ ಸರ್ 11/9.
11/9 ಗ
11/9.
ಅವ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಬಂದಿದ್ರಾ ಮೇಡಮ್? ಇಫ್ ಯು ಡೋಂಟ್ ಮೈಂಡ್, ಸಾರಿ.
The petitioner ಇದ್ರು.
ಪೆಟಿಷನರ್ ಇದ್ರ? ನಾವು ಇದ್ರಲ್ಲಿ ಪೆಟಿಷನರ್.
Kiran for respondent is not present.
Oh, I was just online. Okay madam.
Yes.
Court officer? Court officer?
ಸರ್ ಏನ್ ಬೇಕು? ಅಕ್ಷಯ್ ಜೈನ್.
ಮೇಡಮ್ ನಮಸ್ತೆ. ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 45 5 PM ಗೆ ಅಂತ ಇದೆಯಲ್ಲ ಮೇಡಮ್?
40?
45 ಲಾಸ್ಟ್ ಮ್ಯಾಟರ್ ಪ್ರಿಲಿಮಿನರಿ ಬಿ.
ಇಟ್ ಈಸ್ ಇನ್ ಚೇಂಬರ್ ಸರ್.
ಸರಿ ಮೇಡಮ್, ಅದು
ಅಲ್ಲಿ
ಕೋರ್ಟ್
ಚೇಂಬರ್ ಹತ್ರ 5 ಗಂಟೆ ಅಷ್ಟರೊಳಗಡೆ ಚೇಂಬರ್ ಹತ್ರ ಬನ್ನಿ. ಪಾರ್ಟೀಸ್ ಅಲಾಂಗ್ ವಿತ್ ದಟ್ ಮದರ್, ಫಾದರ್ ಅಂಡ್ ಚೈಲ್ಡ್.
ಓಕೆ, ಡೈರೆಕ್ಟ್ ಚೇಂಬರ್ ಹತ್ರ ಬರೋದಾ 5 ಗಂಟೆಗೆ?
ಹೌದು.
ಸರಿ ಮೇಡಮ್, ಓಕೆ.
ಎನಿ ಇನ್ ಚೇಂಬರ್ ಮ್ಯಾಟರ್ಸ್ ಇನ್ ದ ಇನ್ ಚೇಂಬರ್.
ಸರಿ ಮೇಡಮ್, ಓಕೆ.
ಅದರ್ ದ್ಯಾನ್ ದಟ್ ಇಫ್ ಯು ವಾಂಟ್ಸ್ ಟು ಸಬ್ಮಿಟ್ ಅಂದ್ರೆ ಮಾತ್ರ.
ಸರಿ, ಓಕೆ ಮೇಡಮ್, ಓಕೆ. 5 ಗಂಟೆಗೆ ನಾವು ಬರ್ತೀವಿ ಮೇಡಮ್. ಥ್ಯಾಂಕ್ ಯು.
ಇಲ್ಲ ಬಂದ್ರೆ ಇದು ಮಾಡ್ತಾ ಇದ್ರಲ್ಲ. ಕೋಟರ್ ಸರ್, ಕೋಟರ್ ಸರ್.
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಇನ್ನ ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ, ಲೇಟ್ ಏನೋ ಅಂತಂದು.
ಬರ್ತಾರೆ ಸರ್, ಬರ್ತಾರೆ.
ಓಕೆ ಮೇಡಮ್. 44 ಮೇಡಮ್.
At 230 matters for serial number 34 minute first list. ಅದರಲ್ಲಿ ದಿಸಾಲ್ ಕೋರ್ಟ್ ಮಲ ಡೈರೆಕ್ಟೆಡ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಕೌಂಟ್ಸ್ ಮಲ ಅದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹ್ಯಾವ್ ಫರ್ನಿಶ್ ದಿ ಪೇಮೆಂಟ್ಸ್ ಡೀಟೇಲ್ಸ್. ನಾನು ನಮ್ಮ ಕ್ಲೈಂಟ್ ಹ್ಯಾವ್ ಸೆಂಡ್ ಸೇಮ್ ಟು ಮೈ ಕ್ಲೈಂಟ್ಸ್. ಅವರು ಇನ್ನೂ ರೆಸ್ಪಾನ್ಸ್ ಮಾಡಿ ಕೈಂಡ್ ವೀಕ್ಸ್ ಟೈಮ್ ಮೇ ಬಿ ಗ್ರಾಂಟೆಡ್.
What has happened to them?
I appeal for the respondent, my lords.
Fast.
Yes.
I appeal for the respondent, my lords. We have filed our memo, my lords.
The request of learned counsel to the
The
petitioner. You were not there
filed
in the
their
morning.
memo of
I'm
calculation.
not there, sorry, I was in 8.
No, I think password was sought. The request of learned counsel, the petitioner posed this matter on 19th of September.
Yes.
All 230 matters, then the passovers.
It's number 3. Non-compliance matters. Serial number 1. Sumati S.
Where is that? On 6/12/2023, 2 weeks' time is granted to comply with the office objections. Then the matter came up on 30/8/2024. As there was no representation on behalf of both the parties, the matter was directed to be listed for dismissal. Again, on 31/8/2024, this matter was directed to be listed for dismissal on 2/9/2024 at 2:30 PM. Today, when the matter came up before the court, there is no representation. And in a appeal of 2023. So far, the office objections are not complied with. Accordingly, the appeal is dismissed for non-prosecution.
Sale number 2, Amar Gowda case for appellant.
This is an appeal of 2023. Office has raised as many as 9 objections. On 31/5/2024, as per the registrar, the counsel for the appellant is absent. And it is observed that in spite of lapse of more than 9 months, the counsel of the appellant does not complied the objections raised by the office and directed the matter to be placed before the court. When this matter came up on 38/2024, as there was no representation, this matter was directed to be listed for dismissal today also. There is no representation on behalf of the appellant. It appears the appellant is not interested to pursue the appeal. Accordingly dismissed for non-prosecution.
Sale
Yes.
number 3, Srinivasa K for appellant.
This is an appeal of 2023. And the office has raised as many as 9 objections. And there was no representation on behalf of before the registrar. The matter was directed to be listed before the court. Even before this court also, on 7/3/2024, this court has granted 2 weeks' time to do the needful. But the appellant had not complied with the objections. And when on 38/2024, the matter is listed as there is no representation, this court has directed the matter to be listed for dismissal today also. There is no representation. It appears that the appellant is not interested to pursue the matter. Dismissed for non-prosecution. Yes.
Sale number 4, Baraknath.
Your lordship, filing memo of withdrawal. Take that. Your lordship. The memo is filed stating that they preferred this appeal against ex parte order of injunction passed in I number 1. Subsequently, the trial court had heard the main matter itself and reserved it for orders. Thereafter, the matter was posted for further hearing on 39/2024. As there is due to change of the presiding officer. Hence, in view of these circumstances, the appellant want to withdraw the MFA. Yes, the memo is taken on record and the appeal is dismissed as withdrawn. Yes.
Sale number 5, Rajeshwari M, petitioner.
The registry has raised 6 objections. And the matter was placed before the court on 7/5/2024. On that day, a week's time is granted to comply with the office objections. Thereafter, the matter came up before this court on 38/2024. As there was no representation, the matter was directed to be listed for dismissal. Same. Yes.
Sale number non-compliance 3rd time. Sale number 6.
2 weeks time, it is
Ishan?
granted, will claim my office objections.
Why 2 weeks' time? This coming up for the 3rd time. Why? The court has no other work that every time it has to post the matter, pass an order, sign that order. Again, you will ask for time. How many times it goes on? There should be some reason
last-
for that.
As a last chance, my lord, 2 weeks. my
Why
lord.
2 weeks' time? What are the objections? Let's see.
Court fee is the main objections. Court fee, my lord.
But then
I
you
have
should
already
pay.
sent.
Without paying the court fees, how your appeal will be entertained? Provision of law to be corrected, delay days to be stated, entire appeal and IAS to be dated, court fee to be made, value of the appeal to be stated along with 100% solatium.
Weeks time, my lord, I will comply with.
Finally, a week's time is granted. And if the office objections are not complied with, within a week from today, the appeal shall stand dismissed without further reference to the court.
Cell number 7,
7 and 8, both are same.
Yes, same.
Please.
cell number,
Please, my lord.
okay,
I
cell
request
number
1
9,
week time may be granted, my lord. There are 3 objections.
What were you doing from the last 3 times?
Week time.
Don't let it not make,
What
let
is
us not,
three
let us
objections?
not make it as a matter of routine that every time it comes and every time you ask.
As a last chance.
For some cause and grant you then, fine. The a week's time is granted on, even in the earlier matter also. Where is the counsel he left?
here,
In the earlier matter also, on
Done
cost of
here.
1,000, on cost of 1,000, a week's time is granted.
The last chance, my lord, if it is not done, then
Uh-huh.
as a last.
It's all for the third time.
My lord, it was before. Clear, my lord, as a last chance, my lord, if not.
Every time it's a last chance. Yes. A week's time is granted, same default order 9,
cell
10.
number 10, J. Shri Narasimhan,
Memo withdrawn.
Take that. A memo is filed stating that the present appeal has become infructuous. Hence, the appeal will be dismissed as withdrawn. Memo is taken on record and the appeal is dismissed as withdrawn. Next 11.
Prashant Beer,
There are 4 connected matters that. Those-
Yes, 11 also, same like 6, 7, 8. Yes.
Please.
12.
cell number 12,
Office objection with regard to production of acknowledgement for having served the David Miller. Copy has been served and they have also filed objection, my lord. In office.
Friendly, yes,
Suppose this
madam.
matter, it is submitted that office objections are complied with. And the copy is served and the respondent poses matter for admission on Wednesday. Yes.
Achha.
cell number 13,
Complaints. Week time.
non-compliance
Office
court time,
objection.
Sheriff Debt,
All this fourth time on cost.
Please. 1 week time.
On one, this court, this is, the matter is coming up under caption, non-compliance of office objections for 4th time. At the request of non-counsel for the appellant, finally a week's time is granted on the condition, on cost of rupees 1,000 to be paid to the Legal Services Authority, High Court Advocates Association. Next 14,
cell number 14, Jagdish,
same order. 1 week, 1,000 costs,
cell
Yes.
number 15,
same week's time, default order also.
Lordship,
cell
kindly pray for 2 days time. We have to get that violation
1,000
slip.
1,000 costs, yes,
cell
2 days
number
time,
16,
as prayed for is granted, yes.
17,
I am for petitioner, my lord. Pray for 1 week time, my lord.
Same, 16 also 1,000 costs, 1 week time, 17.
17,
I am for petitioner, my lord. In 17 serial number.
Mm.
Pray for 1 week time.
1,000 costs, 1 week,
cell number
Yes.
18,
I am for petitioner, my lord. Serial number is
that's
18.
what I'm saying, you're for the petitioner. On cost of rupees 1,000, 1 week time is granted for complaints of office objections. Yes,
Much
next.
obliged.
cell number 19, R. Ramesh Kumar,
I pray for a week's time for compliance.
Same order.
cell number 20, N. Suresh,
No representation, post this matter for dismissal tomorrow. Yes, call the passwords. 230 matter for, yeah.
for compliance, for orders matters in list number 1, 230 matters. Cell number 37, Syed Kamruddin,
For the appellants, my lord, kindly issue notice to the respondent number 4 for the 3rd time. Process fee has been paid
When did you pay?
today, my lords.
It is submitted that the office objections are complied with.
Not office objections. No office
Yes.
objections. That's it.
Submitted that the process is paid, the needful is done. Pose this matter after service of notice.
Cell
Yes.
number 38. K. Prasanna Shetty.
For the dismissal of R1, my lord, we have filed a LR application, application for abatement of, setting aside of other abatement has to be filed, my lord. Kindly provide 1 minute time. And we have served the copy.
Time,
My lord,
finally, a
kindly
week's time is
provide a date,
granted for
my lord.
complying with the office objections, same default order.
My lord,
Next.
kindly provide the date, my lord.
Huh?
Kindly provide a date, my lord, for the next week.
1 week from today.
A date may be given, my lord.
Oh, the office objections have to be complied with by 9th.
Published.
Yes.
Cell number 39.
For,
Kalyan.
appellant. So I'm filing memo for dispensation of notice to respondent number 1, 4 to 7.
No, the process has to be paid to R1, R2, R4, R7.
R4 to 7. I have filed memo for.
All of them you are
dispensation
seeking dispense with.
of
R
Respondent number
one.
3 at
Next,
5
non-compliance
objections.
of office objections raised on IA number 2 of 24. That is affidavit in IA's found.
But IA number 2, I have filed IA number 2, my lord, on Saturday. My lord, by oversight, I did not mention to
Do that, the comply with that.
extension of interim order application that I have filed. Interim order was there till 31. On 31, I have, by oversight, I did
No,
not.
no, whatever they are saying about the compliance office objection, that you comply with.
My lord, I'll comply that. Meanwhile, interim order may kindly.
That is for,
No.
that is what is for, unless and until you comply with the office objections, how will we grant? We'll have it on Wednesday, do it in the meantime. A memo is filed seeking dispensation of notice to respondent number 1, 2, and 4 to 7. The memo is taken on record and notice to so-and-so is dispensed with at the risk of appellant. Second, next
Number 40.
he has to comply with the office objections on I number 2. He has to comply with the other office objections. Post this matter on Wednesday if the office objections are complied with.
Cell
Yes.
number 40. Clean Gomes.
Post after service of notice.
Cell number 41.
41, my lord. I served the copy on the advocate. I produced the copy of the, already I produced on 30th, my lord. And even the amount 25,000 is transferred to the account of the first respondent on 29th itself. In advance, we have paid to 20,000 extra. 5,000 had to be paid.
Is a memo, where is the order?
Memo is filed.
Petitioner serve the copy of the petition with connection to the advocate and Jaffa appearing for the respondent and the file of the family. Court.
29th, I have transferred 25,000 in advance.
Also, the petitioner submits that he has already he has complied with the order passed by this court dated 31/7/2024 and also served the notice on the council appearing for the respondent before the trial court and also filed a memo to that effect. Bring the name of Mr.
Anjanappa.
Anjappa. Bring the name of Mr. Anjappa.
An amount of 25,000 is transferred.
For Anjappa, pose this matter on September 23rd.
Cell number 42.
Interim order, look at it. If it's a limited interim order, extend it to the next date of hearing. Yes, 40.
Interim order, my lord, was granted without any conditions. I had to deposit 5,000 rupees every 5th of every month. And there is no
Inside as till the next
specific
date of
date.
hearing. Must be till the next date of hearing. Yes, 42.
Cell number 42. Sarvana S.
Also, may kindly take to annexure D, page 17.
What is this memo for clubbing?
There is
filed
appeal
by
is also
IC?
pending.
Concerned with office objections, rectification of office objections raised on counter filed by party in person.
My lordship, I'm the respondent here.
Yes. What about office objections? I think you have to sign.
My lord, yes, my lordship, I have been coming from Bombay, and the last time after I filed the counter, the trains to Bangalore have been cancelled off. So I have not been able to reach Bangalore to sign the counter. But when I'm there, I will surely sign the documents once I'm there in Bangalore.
It's not that, whenever you are there, it's not about you signing it. You have to comply with that. If the matter has.
No,
to
my
be
lordship,
reviewed.
the trains are not coming. The trains have been cancelled. I had 3 times the trains got cancelled to Bangalore because of due to landslides between Bangalore and Bangalore, the trains have been cancelled 3 times. And that's the reason I couldn't be present before this honorable court today also.
Is it so? Now the trains are not there.
I don't know. I really don't know.
It started only for a day. On the 14th, it was there for a day. And then it got cancelled again because of the landslide.
Pose this matter after 4 weeks. Yes,
Cell number 43,
yes.
Suyo Kerala.
Your Lordships, the petitioner has served it on the advocate in the trial court.
Filed a memo.
Please, Your Lordship.
Where
It's
is it?
also will file. We are yet to receive the original acknowledgement. I have just a scanned copy of it.
It is submitted that the council has already served the copy.
It's
As per the
also-
orders passed by this court on the council appearing before the trial court for the respondent and for filing a memo, takes time.
He's also
Pose this
deposited
matter
the
on next week. Yes.
My lordship, if a date can be given so I can book my tickets accordingly, because the cause list comes only a night before
October 14th.
October 14th. Much obliged, my lordship.
Yeah.
Cell number 44,
Post after service of notice.
My lord, I am the petitioner. It is awaiting, my lord.
Yes,
I came to know that it is served.
yes, 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 next.
October matters, cell number 12. Yeshu Baba Mishra.
Yes.
Before he can start, my lord. I'm getting the translation copy. I thought he has given the translation. He has not given the translation. He can start, my lord. Only one thing, my lord. This last moment serving of the copy. I was under the impression it is only pertaining to the suit. Hidden way, there is one writ petition is given along with this, which they have filed. This is not the way, my lord. They have to serve the copy in advance. One writ petition they have.
That's why I
filed.
asked you, you want to go ahead, proceed with
Because
the
I'm under the
matter or
impression
you
this
want?
is entire suit documents. One document in the last is a writ petition, which they have filed, and we have not even received notice in that. It's not the way, my lord. They should serve the copy well in advance. He can proceed with the matter, my lord. I'll give the translation copy.
Yes. Where are the
Because, my lord,
documents
my
he has given?
learned friend raised an objection that I have not questioned that order, on the basis of which the revenue entries have been made.
Please tell the facts. What is the suit for?
My lord, the suit is for declaration of title
Hmm.
and for injunction.
You are the plaintiff.
I am the defendant. We are defendants 2 to 7. Defendant number 1 is a trust. Satya Sai Lok Seva Trust. We have filed one set of written statements. Defendant number 1 has filed its own written statement. Now, my lord, what has happened?
Who are 2 to 7?
2 to 7, my lord, now they have made us part, actually, my lord, we are trustees of the central trust. That is the appellants, trustees of the central, Satya Sai Central Trust. Both the trusts, my lord, were established by Bhagwan Satya Sai. Subsequently, there have been disputes between these trusts after his passing. Now, they made an amendment to the central trust, attempting to take over the trust. There was a suit filed at Bantwa. In that suit, there is an injunction against them acting as trustees. They're admitted. And that has become final, that order. And that suit is at an advanced stage. There is evidence almost concluding, plaintiff's evidence is almost concluding. Now,
What is the suit for? Declaration of?
this is a suit for declaration of title. My lords may kindly take note the main booklet.
The booklet you passed on now?
No, my lord, the main MFA.
Where is the page number?
At page 75 is the plain. Page 75 is the plain, my lord.
To declare that the plaintiff is the absolute owner and possession of the suit scheduled property. Lease deed dated, created by the defendants as null and void.
Null and void.
claiming under them interfering with the so-and-so. So what is the case of the plaintiff?
My lord, case of the plaintiff, my lord, my lords may take the booklet that I have now filed, my lord, the
Yes.
compilation.
Yes.
My lord, the case of the plaintiff,
Yes.
that the plaintiff was granted 4 acres of land
Hmm.
in survey number 27
Hmm.
by a grant certificate dated 1/5/1973.
How it is granted?
By a grant certificate dated
By a grant.
by.
Hmm.
Lord,
What is the nature of the grant?
My lord, it is under the Karnataka land grant rules.
Hmm.
There is a grant according to the plaintiff in his favor for 4 acres and 6 guntas
Hmm.
in survey number 27 of Chikkamuddenahalli village.
Hmm.
And subsequently, according to the plaintiff, that 4 acres has been given a new survey number 43.
49.
43.
43. Earlier it is 27.
Earlier it was 27.
Resurvey, any resurvey was done?
Resurvey was done according to the plaintiff on 12/12. There is an order of the Tahsildar dated 12/12/2013,
Hmm.
where according to the plaintiff, this 4 acres was given a new survey. My case is that I have purchased, that is the Lok Seva Trust.
Hmm.
Plaintiff was also an active member of all these trusts. That's another fact. Now, it is my case that I have purchased the property under a sale deed. A sale deed dated 17/7/1982. Not this suit property. I have purchased property measuring 37 guntas in survey number 43 of Chikkamuddenahalli village.
Hmm.
1982.
Yes, their purchase, their grant is in 1973.
73, and it is in 27 survey number. My purchase is of survey number 43.
After
There-
purchasing the property, what you did?
What?
After purchasing the property in the year 1983, what you did?
My
What
lord,
are
the
the
land stands in
developments?
my name. There is not.
Any development from there?
My lord, a school is being run. That is why we have taken
When
it.
is
on a
it,
list.
when the school is constructed?
My lord, I am not sure about the construction. It was a very old this thing, but there is a school running. The building, in fact, has been constructed for the purpose of running a school. It is a very old this thing. The school is running. Central Trust. Subsequently, the Central Trust, my lord, has taken a lease of this property on 26/2017, along with 20th of June 2017, where registered lease deed. It is a lease for 27 years.
Yes. Yes.
Now at this stage, my lords may see the compilation I have filed, my lord. In that page number 26. Ink page number 26.
Yes.
All of a sudden, my lord, survey number 27 belonging to them is given survey number 43. And survey number 43 belonging to me is given survey number 27. My land is 40, my land survey number 43. My lords may kindly see, my lord, the
After the resurvey, what is the number allotted to your land?
my lord,
Yours is 22.
serial number 3, my lord. Serial number 3, the tabular column in that.
It's 23/1.
23/1. 37, 35. This has been done without any notice. This is just a sheet of paper written by the Tahsildar without notices to anybody, admittedly. This order does not even say that notices have been issued. I have conducted a survey and these people are found to be in these portions of land.
Yes.
No survey is conducted, nothing is told to us. And on the basis of this, the plaintiff is claiming. This is the disputed document. This is the only document where, under which they. Now, my lords, along with this document, kindly see the first document, page number 2, which is the grant certificate. That is the grant certificate. Not there, the boundaries aren't there.
Yes.
Even on this document, there are no boundaries to their property, 4 acres.
Yes.
So boundaries were never given to their property. Now what happens in 2011 after passing of Bhagwan Satyasai? This happens. This 2013 order comes. No boundaries are given. To my property, my lord, there is a sale deed. There are boundaries. The conversion order, next document.
Page number?
Page number 27 to page number 30. For the first time, their property is given boundaries. No basis. Absolutely no basis.
Conversion was done in the year 2014.
2014, Lord. 7/5/2014.
Yes.
And suddenly these boundaries appear for no reason. No survey has been done.
Yes.
No survey authority.
Yes, yes.
So
Yes.
on the basis of this now, the plaintiff claims that survey number 27 has become survey number 43 and 4 acres of land is mine. My lords may kindly see the schedule of the suit. That's again in the, not in this booklet, the other booklet. Page number 82.
Before going into all that, let's just see the order and then go to that, so that court will be able to better appreciate the facts. Come to the order,
Impugned order.
impugned order, so that the court will understand.
Impugned order, my lord, is at page 35. Lord, paragraph 14. The principles and the case laws which are relied upon by defendants are not applicable to the facts of case. This is because learned counsel so and so. Section, next page, Lord. Section 90 of Indian Evidence Act, where any document purporting or proved to be 30 years old is produced from any custody, which the court is in particular case considers proper, the court may presume that the signature and every other part of such document which purports to be in handwriting of any particular person is in that person's handwriting, and in case of a document executed or attested, that it was duly executed and attested by the persons by whom it purports to be executed and attested. Therefore, Section 90 of Indian Evidence Act, the inference can be drawn in favor of plaintiff with regard to grant certificate with respect to suit schedule property. Later on, it was coded and converted for educational purposes. The documents which are placed by the plaintiff is so probable than the documents which are placed by the defendant. By considering probability, I find that at this junction, the possession of plaintiff is to be protected, which is for educational purpose. Moreover, the case laws which are relied upon by defendants are applicable in favor of plaintiff case. The lease deed which executed among defendants are strongly disputed by the plaintiff. If injunction order is not granted, plaintiff would be dispossessed from the suit schedule property and he would be put into a greater hardship. If temporary injunction order is granted, no such hardship would be caused to the defendant. But my submission is,
No, it is a case that they are the owners of the property. According to you, you are the owner of the property. At this point of time, with regard to who is the owner and what are the other things, now the court cannot go into. What is wrong with this, not to create third party right?
my lord, my.
You're running a school in that, continue to do it. Nobody is stopping from you.
Not running, my lord. That's a very. false
Even,
submission.
let
He's not even in possession of that. Possession is the Satyasai Lok Seva Trust. They are not even Lok Seva Trust. They are illegally made trust, which is their own document will speak. I will demonstrate. But he is not even aware of the school. He doesn't know anything about the school. I can actually give more picture.
Yes, Mr. Counsel.
My lord, there is an order of a court, my lord. I'll take my lord. There is an order of this honorable court. My lords may kindly say, my learned friend last time also said, I know nothing and I am misleading. My lords may see, my lord, this honorable court has passed an order. I'll take my lords through that. I have produced that. I have produced that before the trial court also.
Even I have produced with a memo.
Yes, please.
My learned friend has produced. My lord, page number
249, my lord.
240. It is a reported judgment. What I have been submitting before this court has been considered and criminal proceedings have been quashed against me.
That's a different issue.
No, but I'll take my lords through the observations made by the court. Their own
Their
arguments.
suit is for declaration. They want their right and
All I
title
am
to the
saying, Lord, they
property.
must make out a prima facie.
My lord, sorry,
First, there must-
sorry to interfere, my lord. In the same judgment, para 8, if your lordship reads, entire picture comes.
Yes.
Lord, to make out a prima facie case, there must be a property. There must be boundaries. They must have some basis to show that these are the boundaries. There, admittedly, the grant certificate has no boundaries. The port.
Please tell the court, without going into all this, if the order of not to alienate is subsisting till the disposal of the suit, what is your problem? The court has not granted injunction. Not to
Court has
interfere.
granted an injunction.
Not to interfere. No, that's not the order. True. It is only not to alienate.
My lord,
For a society, according to you, you're running something in that place, you continue to do it.
my lord, for whatever kind of injunction, Lord, they must make out a prima facie case. They must show that there is a property existing. If they take an injunction against a trust like a charitable trust like mine, my lord, people will have a wrong impression that I am encroaching the property of some third parties. I have nothing to do with that. My title is of the year 1982, without notice to me.
All those things have to be decided by the court.
Well, admittedly, prima facie looking at it, that the order itself says,
His prima facie cases, his title is granted.
well, there are no boundaries.
We will see. That we will see.
But
What
there
is
are
the-
no
what is the
boundaries.
big-
The survey number changes without notice to me.
No, every order that is passed by trial court it's not there as a procedure, it should be questioned before the appellate.
No, my lord, I am not as a procedure. My lords may see, there is no identity of the property. Survey number 27 becomes 43 without notice to me. I am in survey number 43 from 82.
One good reason, that's what I'm asking.
And
you. What is the difficulty if this order is subsisting? What is that you are going to do? What is the hardship to the defendant if this order is granted? That you can tell the court.
An injunction or a pending FIR against a person shows on his reputation. If there is an injunction against me, Lord, they must make out a reason and take an injunction. They must make out a case and take an injunction. I am a trust, my lord. I am a trust these are people who are parties to the trust earlier. They have been injuncted by an order of the civil court which has not been questioned by them. I have produced that order also. That is their conduct. They went to an extent of amending the central trust by passing their own resolutions and by unilaterally having an amendment thing.
No, the property has to be preserved till the suit is declared.
I will undertake, my lord, that I will not, but not with an injunction.
What is that?
I will say, why I say that, my lord, it is a question of reputation. they can go and show people that we have an injunction against these people.
Yes.
These people are trying to sell the property.
We'll record that. We'll record and we'll.
I am ready to give an hundred. I will file an affidavit that I will not
File an
alienate. the
affidavit.
property. I will file an affidavit.
When you can file.
All I say is there should not be an injunction against me just because it will not cause any harm to anybody. It may not cause.
File
any-
an affidavit. Post this matter on when Thursday?
Very well.
No,
Post this
Thursday,
matter on
not on
Thursday.
Thursday, madam. Some other day in the next week, madam.
No, nothing else. That affidavit will be recorded.
I
The
have to
same
there,
order
my
will
lord.
be
I may
continued.
not be in station.
Tuesday. Tuesday, that
Very
is.
well, madam. Obliged, madam, 10th, madam.
10. Yes.
Great.
Number 18,
Great.
cell number 18. Arvind Babu, J for petitioner, Veena.
Responded, my lord.
18.
My lord, designated senior is appearing in this case, my lord. Designated senior is appearing in this case, my lord. He's held up in another court. A short
Why
bench.
morning you ask for a passover, again afternoon you, then he has to wait from the morning for your senior to come. Why should he wait?
You are
No, it's
under-
for you, if whomsoever you have designated, you should be there before the court when the matter is called.
Unfortunately, the matter there was not over, my lord. That's why it will come. It may be taken up on Thursday, my lord, 5th.
Thursday, yeah, it will be argued.
Yes, my lord, yes.
Post this matter.
Thursday, I think I am not there.
When do you want? You should have at least informed him in the morning. He was waiting here from morning. Post this matter on 18th of September at the request of Land Council for the. response. 18th,
9th, I can.
9th. 9th not possible. If
18th, okay.
10th.
10th is
10th.
obliged.
10th already more matters are there.
Millard,
Then we'll have it on 14th.
14th, okay, Millard, I just want to make one small submission. Last time, they only said they want to dispose it up. I agreed. And 31st was given a date because I was traveling out. I requested for today. And I rushed back yesterday night. I came back only today early morning by road. I didn't even have a proper this. I am an insulin taking person. Because they took this in the morning, I waited here. I couldn't take my insulin. So, I mean, if they have asked for it, disposal, I am ready right from the first day. I am being unnecessarily troubled. That's the way I will put.
Next time, we will dispose it of whether they argue or not. Come on that day. Yes.
We will argue on
It's
14th. my lord.
14th. 14th.
14th is it?
14th is holiday.
Not 14th, 13th.
13th.
13-9.
Yes.
Cell number 32. Sachin BS. For petitioner, Venkatesh Somareddy. P. Hegde.
There are two writ petition. One is from the wife.
Where is the
One is. I think he's end up in a.
Lord seniors held up in another court hall, my lord. Kindly grant a short accommodation, my lord. Matter may be taken up tomorrow also, my lord.
Now onwards, I'll not grant any passovers. Because today, all the matters, every advocate asks for a passover, and in the afternoon, you come and say that it is not convenient.
No, my lord, he was.
Matters has to be argued convenient to
He's
the
ready,
court.
my lord, but he's before court hall 1, my lord, that's.
This is also a court.
Yes, my lord, Matter may be taken up tomorrow.
You
also.
have any urgency in this? Any interim order in your favor? Please come.
Sorry, madam.
Every matter from morning passed over, morning senior counsel busy, evening senior counsel busy.
Please.
Yes. Please argue.
Please, I represent the wife.
Yours.
And he represent the husband.
32.
There are two
My
matters.
lords,
The two matters. 32. First matter. By the husband. Which I represent. First.
Yes. What are these what is
My lords,
the order?
It is, the matters between husband and wife, matter was pending in Mumbai. Husband filed an application for transfer of that case. Wife is employed in Canada in a bank. So in the transfer petition, Honorable Supreme Court called both parties, made efforts and a very lengthy efforts and who found that she is also employed. Husband
Oh,
is
is it the case where that cost for traveling?
exactly same.
Hmm.
Actually, my lord said that cannot be indirectly, my lord cannot be interpreted. We have paid that amount. Case is going on in the trial court. I'm informed.
So you question only that. So your writ petition has to go.
Please, my lord, and that was connected.
What is
when-
their writ petition?
Their writ
My
petition
lord,
they should be paid,
my application claiming
maintenance.
interim maintenance was rejected.
Hmm.
And court has granted me traveling expenses.
That now they are going to pay that.
They have already paid me.
So your petition also has to go.
No, 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 no.
Why you are
Made an
earning so
application.
much? Why you want interim maintenance?
Yes, I'm sorry. It is not easy like what the opponent has said.
No, I read the order on the last.
Yes,
time.
my lords has read. My lords, I made an application seeking interim maintenance of rupees 1,50,000.
Hmm.
My client is a graduate, MA, this thing, MA, she's a graduate of MA in political science.
Hmm.
The husband is a doctor, MBBS, what is his qualification under? MD in community medicine. MD in community medicine. I made an application for maintenance, which was declined by the family court. And however, the court has ordered only for traveling expense from Mumbai to Mangalore. Agreed by that order, to that extent order, that is
They have come
grant
before
of
the court.
traveling expense, the husband has preferred a writ petition. I am before this court, agreed by the family court order declining me
Come
to
to the
grant
family
the.
court's order, why the
Correct.
family court?
Yes,
had,
my lords,
rejected
before
it?
take my lords to the finding, I just place two things. Family court declined maintenance on two grounds. I have suppressed the material facts.
Hmm.
And second thing is that I have got sufficient income. Court has not dealt with the income of the husband. Just it has gone with the income of the wife. This is
What
how
is the
the
income of
family
the-
court dealt with that.
What is the income of the wife?
Yes, I just place it. My lords, I take my lords, first of all, my lords, straight away, I take my lords to the finding. My lords who find it at page number 43. I take my lords to directly to the finding, how the
43.
court has dealt with the
This is
case of the
second case. Next
Nanna
case.
writ petition, my writ petition. My writ petition, that is
43.
8425, which I have supplied. Ideyala?
842.
Yes,
Yeah. Page 43,
yes.
yes. My submission as family court has not looked into the entire materials to put it in short, that is my argument. I'll take my lords to page number 43. Page 42 may be seen, my lords, the affidavit is culled out. Affidavit in terms of Rajini versus Neha has been culled out, 42. It starts from 28, para 28. It means that when she files an affidavit on 21/11/2023 as well as 13/12/2023, she failed to disclose either alienation of any immovable property standing in her name or acquisition of any property in her name. When this court directed her to submit her taxpayer information summary TDS, she is compelled to disclose the acquisition and alienation of immovable property at Mumbai. It is pertinent to note here that her TIS for assessment year 2023 discloses that she sold the security and units of mutual funds of rupees 10,45,424. She purchased two immobile property. Kindly mark this, two immobile properties. This is factually incorrect. For total consideration amount rupees 2 crores 7 lakhs 99 lakhs 741. This is also factually incorrect. And for sum of rupees 1 crore 8 lakhs 82,141. And another property for sum of rupees 99 lakhs 17,600. This is also factually incorrect. The TAS for assessment year 2023-24 shows that she sold the property for sum of rupees 56 lakhs 33,139. All these information gathered from her TAS clearly shows that she purchased the more than 2 crores and sold the property of rupees 56 lakhs 33,130. 2 crores is factually incorrect. Kindly mark this. Next. No doubt that she has produced some family agreement, registered gift deed, etc. But all the same are subsequent to commencement of litigation. Kindly, this is also factually incorrect. Family agreement is before the litigation. Gift deed was subsequent. Therefore, at this stage of the proceedings, that too, while considering the present application, in my opinion, those gift deeds, family settlement deeds cannot be considered. If the said documents were much prior to commencement of litigation, before the marriage of the petitioner, respondent, then the matter would have been different. But the thing remained as it is that respondent during the year 2021-22 purchased the two properties for consideration amount of fees 2 crore, and for the year 2023 she sold the property for more than 56 lakhs. These materials have been suppressed by the best reason known to her. This is the finding. Next, admittedly their marriage was solemnized on 5/12/2020 at Mangalore, but interestingly she shown her as a single in her income tax return filed for tax year 2020 and 2021 before the Revenue Agency of Canada. It is relevant to note here that on 30/4/2021, she filed her income tax returns for the tax year 2020. And 29/3/2022, she filed income tax returns for the tax year 2021. But in both the said income tax returns, she shown her marital status as single. Even though at the time of filing said returns, she was married. Of course, this is irrelevant, but however, the court has noted it. But however, while filing income tax return for the tax year 2022 on 5/12/2023, for the first time, she has shown her marital status married. But at this stage, apparently on the face of the record, it's clear that she gave false information about the marital status before the Canada Revenue Agency. The said fact is, though not much relevant for deciding the present application, but it shows that she has a habit of suppressing true facts. Pertinent to note here that respondent is claiming 5 lakhs towards the cost of litigation, alleging she spent the huge amount for
statement of assessor liability.
Yes, sir. Yes. My lords, we filed 2 statements of accounts and liabilities. My lords, the original records which I placed along with my memo, out on call, which is already on record before.
Take that.
My lords, there are 2 affidavits. That is, one is affidavit filed
Come
on.
to her expenditure.
Sir?
Come to her expenditure.
Yes, yes, ma'am. My lords would get it at page number. Page 4 of my memo. My lords got it, my lords. In this, I have stated that this is the cost, my lords, 1 crore, 1,40,000.
In that 20,000 has to be deducted because they are paying for your air travel.
Traveling the effective.
Medical expenses, health.
It's only
insurance,
effective.
10,000.
They are paying.
Grocery and laundry charges as per month 15,000.
Yes.
Electricity 10,000. Miscellaneous expenses.
Yes.
2,000. Legal expenses 20,000.
Yes. My lords, I'll just give
No,
you small
this-
dates, my lords, for that.
If your expenses are 1,20,000, how much you are earning?
Please, my lords.
Every month, how much you are earning?
I'm not earning anything. I left the job, everything, because I'm staying in Bombay. Now I want to attend the family court at Mangalore. Nobody gives me job because I should attend the family court. I was in ICSE bank. I got resigned. I left the job. Now the family court holds that I have suppressed the material. I got purchased 2 property. All are factually incorrect. That is the reason why I placed that documents on record along with them.
Why you are saying that you will not get a job?
Because I should attend it, because my parents are staying in Bombay. I should attend the court proceedings and all, then it's very difficult for me to, because from Bombay to Mangalore, it's very difficult to travel.
You have a flight.
There is
Husband
always
is paying
there, but
husband is paying the.
because of the shock which,
No,
yes.
It is like something which.
Yes, my
cannot
lords
be
is right.
accepted.
Yes, exactly. My lords, now, because of the petition filed by the husband, I was shocked and got it resigned. I am not able to work because of the mental
When was the
pressure.
marriage?
Yes, that's the reason why. My lords, marriage takes place on 5th December 2020.
5th December?
2020.
Hmm.
My lords, wife worked in India for a period from April 2020 to 15/1/2021 in child organization Mangalore.
Hmm.
Then wife works in ICIC Bank in Mumbai from April 2021 to July 2022.
What is the salary at that point?
Yes, salary which I have called out in my affidavit. This is the salary. Huh? 25,000, my lords, is the salary. Yes.
When they were separated?
Yes, yes. My lords, separation was on 5/7/2021. Divorce petition on 2/7/2021.
27?
21. 27/2021. I'm sorry.
27?
2021. Yes. This is the gist of dates.
So from 2021 till now, she's not working.
Not working. My lords, wife worked in ICIC Bank in Mumbai from April 2021 to July 2022 is the last which I'm.
Then
Yes, my lords. Then my lords will.
where from according to you, the court has inferred all this about the
Yes, yes,
properties?
yes, yes. My lords, straight away, there is a reason why I placed the document on record. My lords, have a look at the documents with regard to the, yes, income tax returns, my lords. Family code refers to income tax returns. My lords would find it at 110 of my memo. Income tax returns of 2021 to 22.
Yes.
My lords got it, my lords.
Yes.
This is the tax returns. My lords would get it at serial number 6. Purchase of immovable property, 2 crore, 7,99,741. Then purchase of securities, these are the details called out. Then I draw my lord's attention to page 111, last column, purchase of immovable property to 2 crores and order. Then my lords, page 112, purchase of immovable property, SFT. This is how the family code, there are 2 properties. Page 112, my lords got it, I'm sorry.
Yes.
See, first column, that is serial number 1 and 2. This is how the court inferred that there are 2 properties. That is, one property is 1 crore and odd, and second is 99 lakhs. Then I draw my lord's attention to page 113. This is how the court has inferred at serial number 4 that I have sold the property.
What are those?
Yes, yes. My lords, I draw my lord's attention. There was a family settlement. What had happened was that my father, he was having a property. He sold that particular property and he intent to purchase new property. So for that purpose, he's a senior citizen. He could not get loan at that point because of COVID period. He could not secure loan. So there was I who have assisted him to purchase the property. I who have assisted from purchasing the property. So in that agreement, I draw my lord's attention to the family agreement. My lords would take my lords to family agreement. That is a part of recording before the family court, page 128. I just read it. This document was placed on record, but this was ignored. This, my lords, have a look at the family agreement dated 13th April 2021, 128, my lords. I'm sorry.
Get it.
My lords, is got it.
Yeah.
128. That agreement date kindly be looked into. This is in a family agreement dated 13/4/2021. The divorce petition was filed on 27/2021. The family court says that this is a document which was done subsequent to the petition. It's factually incorrect. My lords, I draw my lords into page 128. This is a family agreement which was entered between the father and daughter. Page 129, very next page. My lords, I just permitted to read. First party herein jointly was so and so number, and which is being scheduled to be sold by the end of April 2021, as they have already received the token and booking amount from the buyer. First party is also a sole owner of ancestral land in Guptur, Kaikamba, Mangalore, Karnataka, gifted to him by his parents, and same being sold by him for valid consideration. Whereas the first party attempted to secure loans from various banks for the purchase of new flat. However, considering the age factor of the first party, loan application were not approved. Faced with this institution, first party sought an assistance from their elder daughter, Lalita Devia Kolo, age over 30 years, residing in Canada, for a housing loan. Unfortunately, due to the present court situation, her travel to India is restricted. She is not a subject. Next matter. Consequently, first party has approached their younger daughter, Delma, hearing the second party. She is a present petitioner who is willing to agree to help the securing housing loan for new home. In consideration of assistance and understanding of second party and her responsibility as a married woman towards her own family, first party has is committed to personally repaying all loan installment monthly until its full repayment. Proceeds from the selling present flat of first party and ancestral property will be transferred to the bank account of second party for the payment of purchase amount of new flat in so and so. Another part of the payment will be done either through bank of either parties depending on the convenience considering the current COVID circumstances. It is expressly agreed that second party cannot sell the new property to any third party without consent and signature of the first party, who is actually, it is explicitly agreed that second party cannot sell the new property to any other third party without the consent and signature of first party, who is the actual owner. It's also agreed that money transferred to the second party after selling ancestral property, the first party is presently invested by her in stocks and securities. Same will be withdrawn by her during the time of payment of new property. Any repayment in the future towards new property. Upon full repayment of the first party, second party herein obligates to transfer her share of the property to the first party. So pursuant to this agreement, the property was purchased jointly in the name of father and daughter. That is my claim. My lords, have a look at that is also a part of record. My lords would get it at page number 199. 199. My lords, 199 of moment. 199.
There is no 199 page number.
It is 149, my lords. 149. It's a mistake. I'm sorry. My lords got it.
Yes.
My lords, it is in Hindi because it's from Bombay. Page 143 is a Hindi version. So I got it translated at page 149 at English version. My lords got it. This is the preamble portion of the sale deed. Yes. Now, my lords, have a look at the remuneration column. This is consideration amount. This is 99 lakh 17,600. And actual price is 1 crore 88 lakhs 21,040. My lords would get it at column number 8. This is a sale deed which was purchased jointly by the father and daughter. My lords got it, column number 8. This is how it is transferred. My lords, whatever because of these arrangements, since the father could not secure the loan, my lords, this is the reason why, my lords, the property was purchased. Now, family court holds that it is a two property which is factually incorrect. This is my respectful submission. Court has not looked into these documents. That is my first submission. So far, second submission is concerned, my lords, have a look at the gift deed also. Pursuant to there, what had happened as per the family arrangement, page 136, my lords. The daughter, that is my client, executes the gift deed. My lords, I'm sorry, page 136.
Yes.
This gift deed is 13/9/2020. That is after filing the petition. That is correct. What the family court finding that deed was gift deed was executed after filing petition of gift deed.
Why the
Correct.
gift deed is executed in favor
Because
of-
the loan which the liability which was taken by the parent, my father, has reimbursed it.
she has reimbursed it.
Yes, the father has reimbursed it. No, what had happened was that loan was taken in my name. The liability to repay was with the father.
It's on the father, correct?
Yes, so
Why
it is my
transferred
duty to.
Daughter.
Yes. Yes, ma'am.
Why it is transferred to the other daughter then? If you look at the gift deed, it is given to the other daughter.
No. She's a mother.
Mother.
Yes. I'm sorry, I should have enlightened my notes. This is how it is transferred.
So earlier in that agreement, when then it appears that she's residing in Canada due to COVID and all is mentioned. She's not mother, I think.
Who?
Come to that sale deed.
Which sale deed? Family agreement.
No,
madam.
family agreement.
Yes.
Come to that.
Yes.
Page number.
Correct. Yes. Page 129, 1, 2, 3, 4. Fourth paragraph. I'm sorry. Fourth paragraph which speaks about the first daughter. COVID, Canada. I'm sorry, minutes. Second party in this agreement is my claim. That is yes.
Faced with this situation, first party sought assistance from their daughter.
Correct. Sir, madam. Yes, first daughter, she is not a party. The second daughter is the present petitioner. I don't see any assistance.
No.
Yes.
You are saying that this gift deed is executed in favor of the mother.
Yes.
But from this, it appears that it is not mother, but it is elder sister.
My lords, Lalicia is the mother. My lords, gift deed. Here, this Lavita. Gift deed is Lalicia. Latia. Here, Lavita. Lavita.
Yes.
Yes, ma'am. My lords got it. Yes. Now, my lords,
Which property number gift deed is made? The very same property.
very same, only one property. Only one property. This was an internal arrangement because the age-old father, she could not secure
Yes,
the
yes,
house. This is
yes,
how
yes.
it was transferred.
So that is
Then
one property.
That is one property. There is no other property. There is no transaction. But in the income tax returns, it gives an impression as if there are
And what about this 15-16 lakhs, the amount that is lying in our bank account?
Yes. My lords, that is my father. My father, no, my lords, he sold the first property and he purchased this subject property. Whatever the amount which the sale consideration from that first property was transferred. Yes, I'm sorry. My lords, no consideration amount is passed on it. This is a gift deed.
No, that I understand.
I'm
Based on
sorry.
that 15 lakhs.
56 lakhs is my lords is pointing out.
1.5.
15. Where it is? Yes, in the bank account transfer. My lords is pointing out the bank account transfer. Yes, my lords. My lords, have a look at I have given explanation also in the notes of argument, how it is. I'll place that statement of account extracts. What are things which had happened? Kindly see page 154.
Yes.
Page 153 is the notes of arguments which are submitted by the wife before the family court. Page 154 is my explanation. Because my statement of account shows of different transactions which has impressed upon the family court to draw. Page 154. Kindly see para 3. Narration the statement produced by the respondent. shows that in the year 2022, she had a salary of rupees 9,45,365. That is for 1 year. Bank of rupees 5,43,172. CHT group rupees 40,21,093. This statement also reflects loan of rupees 15,77,553.
No, if her salary is 25,000 per month,
Correct.
where is this 9,45,000? And she, according to you, she worked for 2 months.
But it's 2 years, 2020 in the 22 one.
For 2 years.
Yes, yes.
Hmm.
2 years. Then, madam, no doubt, learned counsel for the petitioner submits that sum of rupees
Her
50.
income should be per year, how much?
Please, my lords.
It would be 3 lakhs.
Yes, yes.
What is this 9,45,365? At para number 3.
Correct. CH group.
Hmm?
Husband, no, my lords, what had happened was that the husband has called me to join with his group. He was running with the CH group. CHT group
No, Malaysia
organization.
is a statement by the respondent
Correct.
shows that
Correct.
in the year 2022, 2022, she had salary income
Correct.
of rupees 9,45,365.
Correct. Which includes, yes. Yes. Yes, my lords, in that, the out of salary income of rupees 9,45,365, 5,43,172 is from the salary which is gained from the bank.
How she will get that much salary?
That's what this thing indicates, statement of accounts. Hello? Huh? ఏంటి? Yes. One year, 4 lakhs. Are you sure? My lords, as per the instruction, it is submitted for 1 year, 4 lakhs is the salary.
It should be 3 lakhs if it is 25,000.
25, correct again. Four lakhs or 3 to 4 lakhs. Can you produce salaries? Yeah. Produce salaries slip. I can produce salaries slip also, there's no issues.
Yes.
So what I want to try to impress upon the court is that, my lords, the family court has not dealt with these things. It has just looked into.
So, and understand that one property.
Yes, yes.
The court had referred to 2 properties.
2 properties.
That is
That's
not
one
2
thing.
properties,
That
it
is
is
one.
1 property.
Yes.
And the property is purchased by the father.
Correct, correct.
She has only, because she only facilitated to obtain the loan.
Yes, yes. Then my affidavit was this thing, what
And her
settlement
income per
also has
month
been
is, her
ignored.
income per month is 25,000.
Correct. My statement that one settlement deed which was executed, that was family arrangement deed which was
Yes, yes,
produced,
yes.
that was also ignored by the family court. So if family court would have been looked these documents, probably the result would have been different.
Yes, Mr. Senior Constable, last. Yes.
Sir, the case is now one aspect of the matter. After the honorable court's observation the other day, the deposited she has come for cross-examination, but every cross-examination has about 15 to 20 times cross-examination has happened. Now it has gone for, again they sought cross-examination, we are cross-examining. They are taking time. And there is in fact a direction by the Supreme Court for a speedy disposal. Now it's, we have deposited the amount, she has come for some dates, several dates she was absent again. And because of the absence, case could not go. And after some cross-examination, again, they seek time, matter is going on. One submission at the very outset is, all these documents which are now produced, the subsequent matter was before the Honorable Supreme Court. There is also an order of the Honorable Supreme Court, page 52, my lords, in my petition.
52 of your people.
Not the maintenance, the question was left open. That is been culled out here.
Read it and say how
Yes.
it is kept open. Page 52, your lords may kindly see.
It is culled out in the judgment also.
How it has happened, how
Page
the
35.
Time has been spent, my lords.
Page 35.
My petition, please. Page 52, my lords, in my petition, please. Page 52. First para is about the transfer, then the marriage, everything has happened in Mangalore. Parties are actually from Mangalore, my lords, originally from Mangalore. Then, my lord, your lords may kindly see page 56.
Yes,
Page 56.
yes.
Para 8. In fact, petitioner being a permanent resident of Canada was habituated of that lifestyle. Marriage was just to spoil the life of the respondent. Initially, it was claimed that she was love sick. It is alleged that the respondent had shunted out the petition from matrimonial home. However, it was her own decision to move out. Immediately after reaching to Mumbai, she applied for job ICICI Bank, the resignation from organization on 9/2/2021, where she was working with the respondent. She had joined the job on so and so. Number of efforts were made by the respondent to reconcile. Para 9. Respondent was also kept in dark about the location of the new flat worth ₹2 crores purchased by her and her family. The respondent came to know about the address when she filed a complaint at so and so, my lord. Now, after this, now I beg to take the honorable court about these contentions about the claim, my lords. Now beg to take the honorable court to page 59. Now I beg to pause it for a moment. These documents, there is an agreement between the father, they are released, etc. Everything comes later. Nothing was there. According to our case, my lord, this alleged family agreement
No,
is.
no, but before the Supreme Court, why it should be?
No. Thereafter, my lord, this matter went on for a long time. It was before the honorable, that question, my lords. There was the honorable Supreme Court spent a lot of time and even appointed one of the honorable High Court judges, my lord. Went on several months, I am informed, my lords. And that also I beg to bring to the kind notes of this honorable court. That, my lord, this document, my lords, that alleged family agreement, is a setup document that is now produced later in the family court, which is disputed by us, my lords. This setup clean as the stamp paper. We don't want to reveal everything, my lords, on the face of it. Stamp paper when it's there, the date when it is there, because all these are now the questions before the.
It's a registered document.
The family document is not registered. In the stamp paper, they have prepared it, my lords. Subsequently, on the old stamp, they prepared it, my lords. That document on the face of it, your lords may kindly see, which is
This
now.
will take that it's not a registered document.
No, not a registered document. The face of it, it appears.
So for what purpose you want to rely on the Supreme Court judgment?
Supreme Court is this, my lords. About this claim, your lords may kindly see page 59.
Yes.
Para 17. From the order dated 13/10/2022, it is evident that the petitioner may be working in Canada, as she stated that she wound up her work in Canada and she is now living in India. They agreed to take assistance to the marriage council. Justice S.J. Wazifdar, former Justice of Punjab and Haryana Court, was appointed as a mediator. The report has been received from the mediator stating that despite spending about 50 hours in different sessions, the parties and family members could not arrive at a family so and settlement failed as per so and so. Specifically, according to the mediator in the report, that during 4 months, several meetings were held with the parties, though the petitioner was in Canada, and she attended the meetings through video conference. Para 18. Then, my lords, I will not read para 18 because it's about the this one, my lords. Then para 19. Petitioner is a permanent resident of Canada. She had shifted there in the year 2014, was working there on a well-paid job. Came to India for the matrimonial alliance. She is presently based at Mumbai, Maharashtra with her parents, stated to be working in ICICI Bank. No child at the marriage. Relations started after the parties met on Facebook. As far as the respondent is concerned, he is a doctor by profession, he is living in Mangalore. Divorce petition has been filed, so and so, husband at Mangalore, where he resides with his aged parents. Then, my lord, para 20, middle portion, my lords, mediation report dated 8/2/23, submitted by Justice H.A. Wazifdar. Petitioner was in Canada throughout the mediation process, attended the mediation there. There is one child born out of the marriage. Both the parties are well educated, engaged in their own jobs and professions. They can travel to Mangalore to attend the hearing of the so can also seek exemption. Though at present condition, the finance condition, the parties, the finance condition of component, we do not find any ground issuing direction to the respondent to pay the expense of the petition in traveling, my lords. Then still she feels like then seeking reimbursement of expenses, my lords. She will be at liberty to file application before the court concerned. Based on that, she filed an application for the expenses, my lords. Now, my lord, even this prayer, etc., was made, my lords. There also.
They have lived together for 40 days.
That's all, man. That's all, man. That's all. And then, my lords, after the matter was transferred to Lord's mechanism, all steps are taken, my lord, to defeat the process of the court, to delay the proceedings. Even though the transfer order, your Lord's mechanism 18/4/2023, my lords, continuously being delayed, despite the specific order is there for this one court to expedite the process, my lords. And kindly see, as far as the orders that have been passed by the family court in the present case, my lord, which is now impugned before this honorable court. That order, the lords may kindly see, 7th February 2024, order was passed. Thereafterwards, my lords, of course, the honorable court in that case, my lords, provided for 8,000. And then, my lords, 8,000, we had an objection because she's never coming. She's continuously dragging on the proceedings, my lords. Then we came up before this honorable court. So since then, it's only because my lord directed that this petition also be tagged with this. Now it is tagged. Now, my lord, the trial judge considers everything as far as they raise up a defense now, my lords. This is not my income, I have resigned, etc. And that the amount of crores has not come from me, father has contributed, etc. These are all, my lord, the defenses which have been subsequently set up, my lords. It's not at all, there's absolutely no truth in all these defenses. Now, my respectful submission is, my lord, the trial court, having regard all the materials, comes to this conclusion, my lord. It cannot be said that it is illegal or perverse, my lords. Now all arguments are advanced making a defense, my lords. The defense is required to be tried. Now, cross-examination is going on. If she cooperates, appears at least 1 or 2 days, one may make one submission, my lords. For a family court, cross-examination, my lords, of either this or the other party, my lords, I respectfully submit it should be for, my lord, 3 hours, 4 hours, or 5 hours at the most total, my lords. Maybe stretching to 1 or 2 days. This, my lords, this is going on. An unfortunate incident, my lords, going on for 2-3 hours every day and for 10 to 15 hearings. Even now they say they are going to cross-examine. Unless this honorable court directs, my lords, that it should be held and she should be present on every day. She will not be present also. She say, I am Mumbai, I am not present. Husband would come, advocate would come and again go. And then said for further cross-examination, time is required. It would not be done. It will never be done, despite the honorable courts directed, my lords, because the honorable court would only direct for expeditious disposal because number of other cases are pending. Now the honorable family court is taking up the matter. I'm informed yesterday, yesterday or day before yesterday it was there. Again, she did not come. And this is a short time. And so they do cross-examination, my lord, for little time, my lords. Then they say one time and go on. And my lord, unless this is controlled, this will never end, my lords. Now the case itself can be over by a month or so if she cooperates with the proceedings. So, my lord, the order of the learned family judge, including both orders, my lords, I humbly beg to submit, my lord, that is already finding given that how she has suppressed and now she has actually concocted false records. We may have to initiate action also for creating a family record on and dating it after 4 months of the illegal stamp paper. January stamp paper, they make it as 4 April. And this is all to defeat the court order, suppress her. And my lord, she was assistant manager, admitted, and worked in Canada for several years. And assistant manager residing along with the parents. Now they say we have resigned. And we left the job. And that is very hard to believe because all the records of income tax, she has other income, my lords. Everything is borne out from the income tax records. Now, my lord, since it's the fag end, my lords, my humble prayer before the honorable court is kindly direct her also to cooperate and finish the case at the earliest, my lords. And the impugned orders, my lords, does not require any interference, merit.
Yes. Please.
My lords, fact is, unregistered document is factually incorrect. It's a registered document.
Family arrangement.
128. It's a registered document.
Afterwards.
Yes, 120. Then, my lords, 128 of my memos.
128. Notary, sir. Before the notary, sir.
Family agreement.
Yes. Register number 06.
That's stamp paper, sir.
Register number. Kindly see. Registered number also is indicate page 130.
No.
It's a registered document.
Huh?
That is one thing.
128
Second thing,
stamp
my
paper,
lords.
Sir, kindly see now itself, my lords, right side, stamp paper is of January and oath commissioner so and so on 13/4/2021, notary.
Let
Stamp
family court
January
decide
20
all
I don't
these
want to
things.
say
Let the
anything.
documents be looked into. Let the
22
family.
January 2021, sir.
What is it?
And stamp paper. And eligible agreement is 13/4/2021. They got a old stamp paper and gets it before the notary and they want to produce this. I don't want to make any comment on the face of it.
My lords, I have produced, they have not objected for it. Now it's for the first time across the bar is making a submission, one thing. Second thing is that my lords, all the not cooperating, all those things is not a matter of record. They have not produced any document to show that I am not cooperating as such. Third thing is that my lords, before marriage, I was staying in Canada. I am not disputing it. And after marriage, he has called me that you should leave the job and come back to India.
Is it a case that you, both of them lived for 40 days?
Please, my
Yes,
lords.
only 40 days.
Please, my lords.
40 days.
40 days?
They live together.
That's all. Nothing more. I am drawn to, my lord, that is the date which I have pointed out. That's correct date according to my submissions. And other things is that my lord's court has not dealt with the income of the husband at all. Has just put on the burden on the wife. I am not missing on the part of the family court that no burden should not be imposed on the wife. I made best efforts to produce all those. Family court has not looked into all the documents. Let the family court redo the whole thing. It is not the case that madam not cooperating. I'm coming down from the Mumbai, I'm cooperating with the family court matter. It's all factually incorrect.
When is this application filed?
Yes, this application is filed on.
Maintenance.
Yes. And my lords, application was filed on, just I'll assist my lords. This application was filed on. Tell you that. Page number 191. I'm sorry, should I assisted my lords? 7/10/2023.
7/10?
2023. I'm told that my lords, he have got 2 flats in Mangalore. One flat in Mangalore, 3 BHK house, and he has got property in Mumbai also. Let him pay at least little sum of money. At least
What is the income of the husband?
the court has never dealt with the income of the husband at all. He suppresses, he doesn't produce any material before the family court, nor family court has insisted to produce any documents. Let court, this family court, let they decide, my lords. If my lords have a look at the impugned order, court never has dealt with the income of the husband, nor it has only imposed burden on the wife. Just see the impugned order of the family.
No, my lords, these repeated submissions is, my lord, that he has been cooperating and appearing. My lord.
And my lords, expenditure is granted.
Aspect also, my lords.
For effective hearing, only the expenditure is granted by the family.
Please.
If there is an effective hearing, then expenditure has to be borne by the husband. Kindly see the impugned order. If it is only effective hearing.
Effective hearings when she appears.
Effective hearing means you appear and do
No, if-
some business
That's what
is
family
conducted
court
in the
say.
court. Otherwise, no.
No, I'm sorry. That's what the family court reads.
Yes, heard reserved. Next.
Grateful.
Number 36. Gautam Raghunath, for petitioner. Kiran Sebastian.
So the respondent in this matter,
Matter wherein the
Last
court
hearing.
had ordered that they comply with the interim directions.
we have
What has
complied-
happened?
We have
Again-
complied in toto matter. Also, as per directions of memo with expenses. And also there are some new developments that have taken place in this case. Showing the copy also.
You should have served it by this time. You are in the court. They should have also, they would have had the, the advantage of looking at it.
On the 16th of August, the child was taken by the mother because she was continuously crying and also she has developed bedwetting, my lord. Taken to Nimans, to a psychiatrist, and then she's been diagnosed with possible suppression anxiety. Now, she has been given medication for this. She's been given some medication for this, for the anxiety that she's developed. Even when he was informed on the 24th and 25th, she handed over the child. She informed. Even on that day, he abuses her. He tells her that I've already won this case. This is what he does. And he
No.
slaps the child in the house.
Oh, we have
Now, what are we-
CCTV cameras everywhere. I shall produce the entire.
Now, what are we doing with the child? The mother does not want to burn the bridges.
How the mother came to know about this?
Child has told her that the father slapped her and asked her to stop crying. Now she's developed bedwetting.
Should be. Just give it. Might I pass this over? How happy the child is with the father.
Copy. Copy may be given, please.
The classic case, how far a mother would go just to prevent a father from access to a child. And all of us would have to learn from the Goa incident, where the mother killed her own child so that the husband doesn't get. It'll all come down to
Not
this
compare- we
ultimately,
cannot
because
compare the such
forcibly taking a
drastic
child every
cases.
single time after a visitation to a doctor and then getting some kind of a report. And each time it's a different story.
My lordship may direct that the doctor do a fresh assessment if this is the case, because we cannot do operation successful patient dead. And she is the mother for the child. Who else can defend a child? She's begging before this honorable court that let the father build a relationship with the child. Let it take some time. Let the child
Your
settle
Lordship, may
down.
kindly
We are
see these
not,
photos.
we're not, let's not force it. If the child has been diagnosed from Nimans, I mentioned the doctor's name also.
What did the doctor say? What is the report?
Suppression anxiety, my lord. Please turn to page number,
Most of the anxiety is the mother says
page
in
number
their
6.
language that she would
No,
be
this
dead.
is,
She will be dead
this
if
is
you
from
leave
the-
and go. And so the child starts crying. Child is perfectly okay after it goes. Child plays happily.
number
The
6 I've
father
placed
feeds
it.
the child. One day they come up with the story, he's feeding biryani. Another day they come up with a story that she's giving 103 temperature. One day it is she's giving cool drinks. I know for a fact that tomorrow POX was going to happen, and I will probably will give an application beforehand that this is their next move.
I'm actually
This is
surprised these
what
kind
has
of
happened.
allegations are
This
made.
is this
We are
is the
not on those
pattern.
terms.
This is the pattern, Your Lordship. It's unfortunate
Then
that
it has to
fathers
be
have to go
shown
through
how,
this.
how they're going to a POXCO case for this. Why would that even be mentioned before
Now
this
they
court?
said he slapped.
Unless,
Slapping
unless,
next.
unless there is some guilt, unless
Yeah,
you've done
there's
something.
guilt,
No, why do
absolutely,
why do you go to that
absolutely.
level? Why do you raise the bar unnecessary and go to such depths?
Where do you get that? That there is separation anxiety. Where did the doctor say?
Where the doctor said. Page number 9. Page number 9, my lord. It's in handwriting. I've typed it out also. Possible suppression anxiety. So page number 9 at the bottom. Page number 9. For clarity, it is at page 12. Page number 12. It's at axis 1. Tablet. And page number 6, the tablet clonazepam has been prescribed. This is for anxiety disorder. Now, n number
That's
of,
all, that is maybe with all that the whatever the mother has given, the feedback, we'll ask the doctor to examine her. What is
Yes,
this
please,
all
please.
happening?
please.
Even on the day when the court had interaction with the child, that day also I specifically indicated to her. She's like, as if like she's a girl of aged 1 or 2 years. That's how she has been taken care
Child
of.
is underdeveloped. She's not met her milestones. She's 6 years old.
Then why,
But
in which class she is?
which class she knows? Standard 1.
Then
She's
she
standard
shouldn't
1.
have, if there is no mental maturity, she shouldn't be in
She's getting
standard 1.
special attention in the school.
No, she shouldn't be in standard 1. She should have been in, in a nursery now.
But she's not of the normal standard of any
Then
child.
why is she, why she joined her in first standard? If the girl requires any special attention, mother should have taken steps. She shouldn't have been in the normal school. Is it not?
Want to produce the grades?
Yes.
We'll produce the grades then, because the grades also are failing. The teachers are concerned about
No,
that.
it's not about she's failing, the no grades. That's not the thing. When there is something not right with the girl, isn't it the
Extra-
mother's responsibility
With
to take
extra
care?
help, she's gone to first standard, first grade. Now, any parent will not want to hold back the child and put them in a disadvantaged position.
Not
Now,
disadvantage
in a
proposition.
school, for example, there's one school in Bangalore where they take children, if they're weak in some subject and put them in a separate class only for that subject.
Mother, the daughter all the time, the way it's always, she all through she's clinging on to the mother, and a girl of 6 years or 7 years will not do like that normally. If she's doing it like, no,
That's
if she's
exactly what
behaving
we're
it,
saying.
if she is behaving in such manner, what did the mother do for that?
Mother has not done anything. That's.
She has to
her hands
show
are
to the
clean.
doctor. She should have gone to NIMHANS much before.
So now
Not today.
the thing is that the child has developed bedwetting and cries, wakes up in the night. That is why she's taking
Please
the
understand
child.
what the court is saying.
Yes,
It's
madam.
not against, it is, the court has nothing against the child or the mother. No, even the other day also I asked her, when she is not
No, she did-
normal, she should have done something.
Correct. So she did not have,
Not till the time the father, visitation is granted to the father.
so she did not have bedwetting or waking up in the night and suddenly crying. Now, after this 5 visitation sessions that we've had, these things have developed. That's why she's taken the child. So what was the reason to take prior to this, when the child was not bedwetting, was
Oh,
not bedwetting?
Unless it is bedwetting, other things are all normal.
Bedwetting, waking up in the night,
No.
crying.
She's not
Showing
bedwetting
anxiety.
earlier, so only if the child is bedwetting, then it's a concern for the mother. Otherwise, the normal behavior, when it is not up to her age.
She's waking up in the night also.
Your
madam,
lordship, they're
taking it
conveniently
care.
not
No, she would do
understanding
with
what
all
your
the
lordship
things
is
that are happening.
No, whatever.
Whatever that
said-
happens in the day, the children would react, so that's the way
Like
they
this
react. to the
reaction
things.
after the visitation has started for the child, what effect it has on the child's
No,
mind?
please understand, she should have taken care of the child much before than this. Not after the father's visitation is granted. No, a girl of 6 years will not behave like that, how the girl is behaving.
I agree. my
Then
lord, I
had she
agree,
taken
but-
to the doctor much earlier, and should have helped the child. Whatever she is in need of, what is lacking with her, why is she not normal like any other girl of that age? Isn't it?
I do agree, my lord, but I beg to differ, because this has started for the child only after this
I
visitation.
think you've seen the girl.
I've seen
I
the
think I've observed in the order also.
Yes, my lord. I
So
would,
don't tell the court that only like she is not normal from the day she is meeting the father. Prior to that, she was normal. What the court is trying to say is, maybe after meeting the father, that must have aggravated. But even before that also, she was not normal.
that was not.
Which,
the-
why the
Prior
mother was not able to understand that?
No, prior to this exercise that has started, she did not have this issue of bedwetting.
Mr. Counsel, why don't you understand?
I'm
Bedwetting
understanding, my
is
lord.
not at all the concern. The concern is about how the child is reacting to people, things and surroundings. Is she of her age? The behavior of the girl is of her age? No. If it is not, she should be she should be given that help to come out of it. And without doing it all the time, taking her and going around, how she will learn? She will not go to anybody.
Your lordship, this visitation's not been going on now. It's been going on for long. It was only the venue change which got confirmed now and sudden problems that arose. Visitation's been going on earlier also, your lordship. So,
That is-
and all along, your lordship has repeated it 4 times, but they choose not to understand that bedwetting happened now. They are not on the aspect of what your lordship's trying to tell them 5 times that. What about the development of the child? What have you done for that? They are not willing to answer. A psychologist will have to be there. A psychiatrist would have to be there. They do an IQ level test for a 3-year-old, 4-year-old, 5-year-old, 6-year-old. And if they feel that they are 1 year behind or 2 years behind, what are the modes in which they need to start developing? They even give them. They give them these very nice small little cartoon things which they have to click on. They start giving them arithmetical development in a very nice fashion. This is how psychologists work. So I understand what your lordship has said. Why hasn't she done any of that? Now she's trying to say she's in grade 6, grade 1 at the year. They don't want to hold her behind, but she's getting some special attention. That's not how it works. That's putting extra pressure on the child when the child's not meeting his milestones. So your lordship is absolutely right. That they're not willing to address. They only want to address the fact that she's suddenly bedwetting. Your lordship, I have filed an application. Your lordship is seeking permission to proceed with contempt. Your lordship, there have been the number of orders that have been violated ever since your lordship even passed an order. It's come up to over 5 violations on different aspects. Your lordship, all I seek is that your lordship, the contempt can be initiated because this is going to be a regular exercise. Today it's slapping, tomorrow it is something else. They will go on. The child is so happy with the grandmother, so happy with the father, enjoys playing, loves to be fed. And in fact, I wanted to seek your lordship, in fact, if it's from 5 to maybe to 7 p.m. because child sleeps in the afternoon for a little while. So in fact, we wanted to seek permission from your lordship saying, is it possible that we could increase the time? In the evening after she wakes up, then we would have another 2 hours. But now this is what they're coming. They're trying to preempt at every stage. And it looks like the mother will stop at nowhere here. The way at each stage the development is going.
She's on medication. Without medicine, we cannot send her. Now, a fresh assessment may be ordered by this honorable court to Nimans.
No, she's
If
not
this
going to
is-
school.
She is going to school, my lord, but
Then how can, but then the, without,
she's
she's
okay with
on
school. She
medication,
has
she
blended.
can't be, she
No, she has
can't.
blended with the school. She's got along with the school. Now, exactly what we're trying to say that why this situation has arisen after this period of time. Why?
Right
Are we unable to
Right
understand this?
from
much?
day
No,
one, right from day one, the mother is reluctant to send the child for no reason. Because court had interacted, court had, in the earlier orders, if you see, court has made a note of that. Right? No, not after all this happened. She says, I'll go let him have the visitation in the mediation center, but
Submission
I'll
of-
not, but he shouldn't be taken to the house.
I agree with the submission of my, that she was okay in the mediation center. We
Why?
did not have this problem because the mother was there. She knows that the mother is there. She has some anxiety problem and she's alone only with the father. So, so her submission, I agree with that the child was okay in the mediation center. Now, why can't we have another exercise to see in the mediation center whether we're going to face the same issue? We don't want to burn the bridges between the father and the daughter. That is not our intent. But if the intent is to
From how
file
long it is
contempt,
happening in the mediation center? From how long the visitation is happening?
long it is.
1 year, your lordship.
1 year. For 1 year, it is happening.
And
For
every
the
time,
next 1 year also, it should happen in the mediation center. No,
and
please
every time the mother
common
comes,
mall,
understand,
mall,
this is not.
a mall or something, in a mall also they've gone and met. In the mediation center also they met. There's a mall close by to the house. Now, with contempt threat over here, that she has violated 5 times various orders. What is this, my lord? We're trying to come to an amicable settlement or
It
solution.
appeared to be an amicable way of.
No, we
dealing
want it to
with
be
it.
amicable. Now, this contempt has become like, those days when just walk into the police station, give a statement, file 498A, arrest the father and mother. Now, contempt has become like that because they don't arrest over there. Why are we using contempt over here? For what reason? For what is the threat?
I will
She's-
say for what reason.
She is cooperating.
Even before, nothing has happened, she has not copied. If you remember, you appeared online, I remember that.
I appeared
But he
online.
said,
I
I'll
advised
instruct
her.
my client that she cannot, this is not the way she can
I have
behave.
advised her. I have advised her. At every step I advised
That
her now.
shows the,
I've
that
advised her
shows
that
the
she has
conduct
to.
of the client.
She has to obey the court order. I've
Why
told her
should you
this.
tell her? Why should you tell her? Can't she understand that?
As an
So
advocate,
that is,
as
from
an
the last
advocate,
1
I'm
year.
emphasizing that
No,
we have
no.
done our duty.
I'm not, please understand, from the last 1 year, she knows she's coming to the court, she know what is the procedure and how the orders have to be implemented. Till you tell her that this has to be done, she didn't do it. So was it not a contempt as on that day? Now forget about what has happened, that our illness and other things, then we will deal with it at a later point of time. As on that day, was it not a contempt? It was a contempt.
Just take an apology from a,
It's not apology, Mr. Counsel.
I do
Please understand.
mothers as such.
Both of you, like 2 counsels, fighting for, it's not for fighting. You have to think about the child and you have to think about the child is all the way with the mother. No, definitely father also needs the child requires love and affection of the father, and he also requires a company.
So that is what I'm stating, my lord.
And unnecessarily you're straining by all this, this applications, their contempt applications, your.
Contempt
this
is not
all
from my
this,
side.
Huh?
Contempt is what they are.
That's what I'm
yes.
saying, their applications and your behavior, both are not in the interest of the child.
Your lordship, last time when I met her
It has to
outside-
happen. And the court, the court is not giving her a long rope. From how many occasions this court has heard?
9th of
How
July,
many
your lordship.
times
Five
In chamber
visitation.
meeting, 9th of
Five
July.
visitation.
Your lordship, 9th of July, in the in-chamber
started? No,
meeting.
this matter is
Prior
coming
to
up
the two,
before
right?
this court from when?
So 5 and
It's
prior to
coming
that
up
2.
from 26/6/2024.
Prior to
Please.
that 2 and then 5. 5, she has met the father. Now this is developed. We brought it to the notice of this honorable court.
No, you say that the father has slapped the child. The father tells that even the mother constantly says that if you go, let the child die.
Yes.
What are all there?
Something.
That is her anxiety, your lordship. So it is all the anxiety, what she claims is all cultivated by the mother. If it's a peaceful environment,
Mother
go
can be-
enjoy with your father
Mother can
and
be
come back.
flogged,
That is
mother
all.
can be accused of everything possible, my lord. It is the mother only has to suffer end of the day. It's the mother only has to suffer. That is what is happening.
Your
Who
lordship,
else will defend a child, my lord?
your lordship, I in fact spoke to
will
both of
defend
them outside last time, your lordship. In fact, I requested her. I said, I'm not in the matter. I'm not a counsel. I'm just saying this. We lawyers will continue making money. You people will go up to the Supreme Court. Another 5 years, you will be fighting. 10 years, you'll be fighting. There is no need. Just amicably resolve it. Then she said, he used to give 10,000 rupees earlier. Now he's not sending. So then I said, you're not been giving visitation. So he brought it down. You tell me, I will tell him immediately.
There also
Then-
some revenge.
then-
Not been giving, so you bought down.
1
the-
minute, 1 minute.
See his
One-
conduct, man.
1 minute, let me finish. So I even attempted to try to resolve this whole thing. I told him, why don't you start? He said, I want to. I have communicated to her. Entire fees I will pay to the school. She does not respond. He wants the details. He wants to send it. She does not respond. Then he showed all the details. In fact, I pulled him up. I said, you're the father. You have to jolly well pay. And he then said, ma'am, I want to pay. And she is not responding. Your lordship, even this, I'm willing, your lordship could decide what he has to pay, we will pay. She earns about 1.5 to 2 lakhs a month. He also earns roughly about the same. Both of them can decide what is the amount to be paid, even that would be done. So last time she mentioned that as an issue. So I thought probably if that is resolved, maybe she will be all right with the visitation. But then every time something different seems to happen, your lordship. Maybe only if they actually,
Till know what your client is paying to.
he was paying even when they didn't file any
3,000
application,
is
he
paying.
still paid 10,000 rupees.
3,000 is paying now, man. I've given the calculation. 2.5 years,
4,000.
3,000 rupees is paying.
4,000.
Also allegations were made on me that on 10/8, that there was no school. At page number 15,
No, your that expenditure, please come to that.
for the entire year, it comes to 3,92,000. So per month, it's coming to 32,666.
32,000?
666 per month. I've given the calculation for the current year, 3,92,000. Whatever the expenses are. School expenses.
Page 43.
extracurricular acti- Page number 1.
Page 43 is the details.
What
with
is
it.
given? What is school?
In the memo that we filed, your lordship, it's at page 43, the school details, your lordship.
So it would be 1,96,000 if it has to be 50%. If it has to be 50%.
Please, lordship, I will not come
Because
today.
mother
after
is
that.
also, both of them are earning the same amount,
Please.
is it not? 2 lakhs, 2 lakhs. No, she shows that it's 3,92,000, that both of them bear half of the expenditure.
Okay with it? Are you okay with it? You okay with
Seems
it?
okay.
You okay with it?
Please, your lordship. I felt that this could be the issue, and that's why I wanted to mention it to your lordship.
No, when the litigation started when?
Please, this litigation's 2020. When did you start this case?
June 2020.
2020.
2020
The
June.
last 4 years, he's not paying anything.
He's paid, he's been
No,
paying
no, for
10,000
last 2
rupees
years,
also.
1.5 years, 3,000 rupees is paid. He reduced this amount from 10, that's submission. He reduced the amount because visitation was an issue.
What, the 3,000, what will happen in
No, no.
3,000?
Your lordship, that was not the case at all. She was even not giving him video call visitation. So, your lordship, it was nothing else but,
All the
It's
things
become
will
like
happen.
pay-per-view, my lord.
please, 10,000 rupees even without her asking, he's sending earlier, just for the child's expenses. Your lordship, I understand. That is why I'm bringing this up even without them raising it. I'm saying
There
this,
is,
your lordship.
if there's absolute love and affection,
People are becoming and how they are reacting.
Very petty.
None of this conduct is like a normal human conduct.
Absolutely, absolutely, your lordship.
there's
Petty.
absolute love and
Whatever
affection.
is the wife doing, like he has a responsibility.
Just be
towards the child.
gracious. They should just be gracious. I understand, your lordship. What happens is that every action has a reaction and then it starts worsening.
If there is love and affection, he will give 100%, my lord, father. He will give 100%.
Let's
Why
talk on
should?
that,
No,
that's
I have
not,
clients, I have
But the
clients who have
mother
offered,
also-
they've offered their debit card to the wife saying that, fine, you spend. Women are not going to waste the money. Our finance minister is also a woman. She
No.
doesn't think. So
Of
what
course,
I'm
this
saying
is
is,
not the application you have not asked for, but the
Ah,
court is
exactly.
considering
Yes,
it.
my lord.
And that
So
are
the-
volunteering and
I bought,
saying it.
I bought it up last time also that he was not paying.
Yes.
Your lordship, but your lordship,
Now,
with respect.
we'll do one thing.
Please.
Now, we'll send this girl to Nimhans. We'll ask them to evaluate what is her state of mind, what is happening. Let them continue for at least 1 or 2 sessions.
Please.
Let them take like 2 or whatever required sessions, at least to come to a opinion, like what is her state of mind?
Please.
What is happening with her?
The only request is if the father could also participate, the reason being it would be otherwise a complete different side of
The
a.
child was assessed alone without the mother. And let this be assessed without the parents and in a sealed envelope given to this honorable court.
The
Take
child
a-
cannot
we'll-
say that the maternal grandfather
a-
had depression. Clearly, a 6-year-old cannot convey that.
But
What
that
is
was-
conveyed in that?
See, those
So-
details were given by the mother.
No.
Those details are given by the mother. Assessment I'm talking about.
So what happens is,
Assessment.
they have interacted with the mother. Whatever, like, she said that, so-and-so, the grandfather is having depression. And then, earlier there was nothing like that. After meeting the father, she started
Yes.
doing it.
Yes.
So these are all the lead questions
Doctors-
for that.
When the psychiatrists ask questions, you have to answer, my lord. Now.
They will also
They will
talk to
he
him.
will be there with.
No, they will also talk to the father. Then the father will tell the doctor how the girl was behaving when he was with him, so that they will also
So,
understand.
my lordship, proposal that let the child be assessed on a day when he's not there and then a day when both of them are there, because the child's
She's not
behavior will
there, it
change.
should be when
The
she's
child's
not there.
behavior
Then
might change, then we will not get the correct
So
picture.
what we do is.
We will not get the
first-
correct picture, my lord.
First, let the doctors interact with the father, with the mother independently,
Yes, ma'am.
number one.
Yes.
That would be the first day. Second day, let the doctors interact with the girl. And if they feel that for further information or further analysis, they need to meet the girl again, let them meet whatever
Please.
the
Yes,
doctor
my lord.
says.
Yes.
Please.
And let him deposit this amount of, when will he deposit? When will he
Tomorrow
transfer?
itself, he says.
What are where are the bank details and all you have?
Yes, I will.
Is he having?
Please, your lordship. No,
transfer-
he
can
doesn't.
transfer
If he
it.
had it, he would have transferred.
No,
He's
her
been
bank
asking
details,
her.
he's
No.
3,000, no?
He's transferring 3,000, so he has.
Huh?
4,000, my lord.
Anyhow, for the very same account for which you're transferring.
In the
4,000,
same, please,
This 1,96,000, you transfer by tomorrow.
please. For the financial year of 2024, 25.
This year, till December, this calculation is till December.
Up to March
No, it's a
2025.
yearly expenses.
Up to March 2025.
It's a yearly expenses.
Yearly expense, so
So
till March.
it's
March,
for,
you can take it-
yes.
Take it till March.
We'll take it as 24 like academic year.
Academic
24 May-
24, 25
till 25
academic.
May.
24-25.
Please,
25.
please. Might I also request this, your lordship? If what is transpired so far is also recorded, reason being, every time they get away with all of this. So far what whatever has transpired, your lordship, that is also
Record
recorded,
it
so
on the-
she's kept
If
on
that-
check.
Hearing will see.
My
We'll
lordship,
give them
these
one more-
allegations,
one-
no,
please,
no,
more-
allegations have been
Please,
thrown
please.
on me continuously. Please see page number 15. 10-8,
Please
school
don't
was there.
start that again.
My lordship.
Please don't start that again. Let us see some, let's go solution based. You have 100 things to say against them. They have 100 things
I'm
against
not saying
you.
anything. Allegations are thrown against me. I'm producing documents.
No, no, let's not go into all that. On the last occasion, the matter came up, this court had directed the mother to place before the court the expenditure of the child. Today, it is stated, the expenditure is placed before the court, wherein, as per the same, the expenditure of the girl for the year is 3,92,000. The Lennon Senior Counsel appearing for the father submits that the father was always ready to take care of the educational and other expenses of the child. But it's a mother, as the mother had never given him the detail, nor she had permitted the father to visit the child. As for the orders passed by this court, according to the mother, they have been complying with the order of the court, and according to the father, the orders are not complied with. It is a case of the mother that because of as she is separated from the mother, that she had developed the separation anxiety, and she started bedwetting and what?
The tablet. And getting up during the night.
And getting up during the nights.
And she's been subscribed.
They submitted that-
Clonazepam.
Huh?
What's that?
Clonazepam
Clonazepam 0.25 mg.
It is submitted that she has been taken to NIMHANS, and considering that a separation anxiety, doctor has given her a tablet which the girl is taking every night. Next, then it is submitted that the visitation can go on in the presence of the mother, so that the girl will not go through all this trauma. Then a senior counsel appearing for the father submits that the visitation, when she visited earlier visitation went on very well, and the girl was gelling well with the grandparents. The mother, with an intention to see that the visitation do not take place, is coming up with one application or the other. And in fact, they have moved an application for
Affidavit.
contempt as orders of this court are violated. This court has perused the prescription by the NIMHANS. Earlier, when this court had interacted with the child, the court felt that the child was not, the development of the child is not up as per her age. And now, and she's always, and the mother also expressed that, and even her, even the basic necessities, she will not ask, and mother has to have a track about it. Considering all this court feels that the valuation of the condition of the daughter is very much necessary in the facts and circumstances of the case. Hence, this court is passing the following order. One, both the father and the mother, along with the child, shall appear before NIMHANS on
Not this week. This week is Ganesh festival. Next week, my lord.
on 9th.
Thanks.
On 9th.
9th.
Please.
On 9th. On 9th. Shall I mention the time also? Or
Yes,
I
my
think
lord.
it's as per their.
As per we have to wait over them.
uh,
Between what time they
who will- Shall be there by 11 o'clock.
10 o'clock, my lord.
By 10 o'clock,
10
the
o'clock.
three of them shall be present. The doctor shall interact with the father, mother independently. And the father, they shall interact with the father along with the daughter. For mother along with the daughter. Thereafter, on the next day, they shall have an independent interaction with the child. After the interaction, if the doctor feels that some more sessions are required or for a complete analysis, they shall, they accordingly, they shall take a call. After finishing, after completing after, the NIMHANS shall place a report, shall send a report to the registrar judicial. Once the report is received, the matter shall be listed on the next day.
Please, Your Lordship. Your Lordship, where Your Lordship has mentioned that Your Lordship had noticed that the child had not met with the development. Also that so far, nothing has been done by the mother so far on that. This is the first time that Your Lordship is ordering it, but the mother has not done that so far, Your Lordship.
It appears.
It could be recorded as
It
even my
appears
comment.
that,
Even-
no,
Please.
it appears that, it appears that the daughter was taken to NIMHANS only when she started the bedwetting and getting up in the night. Getting up in the night, and earlier she was not taken to the doctors doctors for any, she was never taken to the doctor nor any other help is provided to her. Yes.
Your Lordship, two issues. On Saturday, he has his visitation, Your Lordship. If that could continue.
Lordship, if this is on Monday, there's Ganesh festival also. This will
Why
also
do you,
disturb.
why do you object to that?
No, my
Now
submission-
you are saying
not-
that, no, both of you are saying now
Submission.
at present, that in a common place or in a public place, it is fine. Let it happen Saturday also,
It's a festival, Sunday,
Sunday.
Sunday.
Let it be a public place.
In a
this
public
time.
place, in a mall, let them meet me.
Sunday.
In a
Your
mall.
Lordship, then we
No,
go.
when they're saying so many about the girl's health condition,
Ma-
unless and until there is a report from the doctors, we cannot analyze at this point of time.
I understand,
But-
Your Lordship. May kindly see the photos, Your Lordship. Just for a minute, Your Lordship, what I have said. I've filed, Your Lordship, along
I
with
was
my
to
memo.
produce photos, my lord, just see that.
Will- Which timestamps, Your
This
Lordship?
Sunday, that is on 8th of September, the father can exercise his station.
What time?
The mother shall bring the child to the, what is the nearby mall?
Meenakshi Mall,
So and so mall. At what time?
12.
At
12 to
12,
4.
at 12 PM. Till what time?
12 to 5, Your Lordship. 12 to 5. Your Lordship.
Okay. 12 to 5, but if she's uncomfortable, let him take his decision to leave.
12 to 5. In the meantime, if the daughter is, if the girl is uncomfortable, she can leave. No, that is where the problem would be. Now, if the court gives such a discretion to the mother, if she wants to take her immediately, then what
Not the
happens?
mother, the child, if the child feels uncomfortable with the father, let him take a call. Let him not aggravate it. Because the next day they're going for assessment. It will damage his prospects. If he's going to
I will
cause
worry about
anxiety.
myself. I can worry
If
about
he's,
myself
if he's
later.
going
and
to
then
cause
we can
anxiety,
worry about ourselves later. Your Lordship, we are already going one step back
I'm
because
purely
it's
arguing.
excellent in the house, how she's enjoying in the bed and
I
he's
saw that.
feeding her and is the
The
mother and all of that.
1 to 5. 1 to 5. Next, the father shall transfer an amount of rupees 96,000.
1,96,000.
1,96,000 to the mother's account by day after tomorrow.
Please, Your Lordship, might it be made part heard and then the next hearing date also, Your Lordship?
For partner, there is a long time.
The next date might be fixed, Your Lordship.
No, immediately whenever the report is sent,
Please.
the registrar judicial, the next day the matter shall be listed.
Please. And if the order of visitation could continue as
Every Sunday.
Order will not be
No.
handed over to the parents.
Huh?
It will be directly to the
They will be given to, it will be sent to the registrar judicial.
confidential.
In a seal cover, the report shall be sent to the registrar judicial.
and the visitations would continue every Sunday.
Till the matter is listed
In a public
on
place.
every, except this, after that, on Saturday, that is, we'll mention the dates also on 14 and 21st, let's say.
Please.
14 and 20, on
Please.
14 and on 14th and 21st of September, in the same manner, in a public place, the father can exercise the visitation. Yes,
Yes, my lord.
done? Yes.
Your Lordship, in submission, serial number 31, there was a technical error. By the time I could come up, the matter got adjourned to 11-9. 11-9, I'm out of station. 5-9 may be better, is what I would request the court.
This sign?
My lord, I appear for the petitioner in this case, my lord. It may be taken up on 5th, my lord.
No, that's already now signed and it is sent also.
Well,